o'clock, and we have a lot on our agenda this morning, so we're going to get started right away. Just from a pure housekeeping perspective, the restrooms are out in the hall immediately here to my right. Please feel free throughout the training to get up, take care of your own personal needs. If you want to get up, get another cup of coffee, get food, just know that that's okay. We're very, very pleased to have you all here today, and with the turnout. This is excellent. My name is Allie O'Malley, and I am currently the CEO of Resolve of Greater Rochester, and I'm also chair of the Education Committee for the Domestic Violence Consortium. This training has been in development for the better part of the last 6 months, and I'll thank the members of the committee who contributed, but this is a very different type of training that we are offering, and we hope you will get a lot out of it today. The theme of our training is exploring accountability options for families impacted by domestic violence. Within the consortium, most of us are involved in one way or another in addressing the needs of victims. And accountability is an important part of the overall conversation. What that looks like can be very, very different from one client to the next. But we're going to really look at that accountability side of the equation today instead of looking at direct victim services. I need to thank the committee members. As I said, this has been a long time coming together. But we have, what's really great about the consortium is kind of the cross-functional approach we take to the work that we do, and the fact that we have representatives from so many different agencies contributing their time, talent, and wisdom to this process. So thank you all for your participation and support in creating this training. When we think about who the consortium is, the consortium's mission is to promote safety for victims, survivors, and their families, ensure offender accountability, and foster community awareness. What's really been interesting for me as chair of this committee and working to develop this particular content is as we talk about accountability, we naturally go to a place of wanting to talk about prevention. Prevention and accountability are very, very closely linked, but they really are different facets of this work. So today we're really going to focus on that accountability piece. We hope you'll get some new information. So what do I mean by accountability? What does the DVC mean by accountability? This is not a DVC specific definition, but it creates a construct for what we're going to talk about today. I took this from vocabulary.com. I actually looked up a bunch of different definitions of accountability to understand what people really mean and what we understand when we hear the term. So what I think is interesting about this particular definition is it talks about the different layers of accountability. So a noun that describes accepting responsibility, be it personal or very public. Government, therefore, has accountability for decisions and laws affecting citizens. An individual has accountability for their acts and behaviors. And sometimes taking accountability means admitting that you made a mistake. Punishment may result, but accountability shows ownership and a willingness to admit mistakes. It's particularly poignant, I think, in the context of domestic violence because victims often struggle with their partners not taking any accountability for their behavior. Victims often feel accountable for the violence that they're enduring. They feel like if they could have done something different, maybe their circumstances would have been different. Maybe the relationship would have worked. Perpetrators are really good at making victims feel like it's their fault. So who becomes accountable in this mix? And even within the issue of domestic violence, there is no violence unless the victim comes forward, right? So we kind of automatically point the accountability lens at the victim. And what we want to focus on today is how does the system actually try to hold perpetrators and offenders accountable? So accountability spans both the public and private domains. And this is one of the pieces that we really wrestled with in trying to come up with an important and relevant conversation today. When we think about the public accountability around domestic violence, that's what the consortium represents, a coordinated community response to domestic violence. What do we do as systems to promote accountability? This notion was created in Duluth, Minnesota, way back in the 1980s, and it's still really the governing tenet of how do we hold offenders accountable today. The focus, however, is primarily on issues around the law and criminal justice, which are really, really important through that accountability lens, and yet we know that many victims are reticent to ever engage with those systems. So what do we do then? What does accountability look like? And then how do we start looking at it to say, accountability, the experience of accountability is very personal. There's a system level accountability, but then there's that individual level of accountability. What do I need to feel like I have experienced accountability in one way or another in relation to my partner? How have I become accountable for my choices in myself as I'm moving through the system? So we're going to talk about things like orders of protection, as well as what happens when people are arrested and prosecuted. What else might accountability look like? What are our obligations in terms of accountability to children? How does accountability shift and change when we're talking about seniors? So where does accountability intersect with this issue, and what are we doing about it collectively and then as individuals? So we're going to talk about three primary components of accountability today. Oftentimes we look at this issue as victim, and offender, and oftentimes children are left out of the conversation. I think we do a pretty good job in the DVC of making sure that children are present in our dialogue, but in the grand scheme of things, very often children continue to be the silent victims. I had an interesting conversation with the media the other day about children are not just witnesses, children are primary victims of domestic violence. So when we think about the systems that are engaged today in the accountability system for domestic violence, born of the Duluth model, you have the courts, you have legislators, and you have law enforcement that are our primary methods of holding people accountable to this issue. When we think about what accountability could be and what a truly coordinated community response could include, we have to think about other systems. We're beginning now to see some inroads in the realm of mental health, and mental health providers getting around this issue of domestic violence and understanding that there has to be services and accountability. But we're still largely missing the faith community, we're missing the education system, we're missing the media, employers, and public assistance programs understand that domestic violence is happening, but are still largely ineffective at responding to it. And then when we think about accountability, we have to think about the different population needs. What do different people need? What does the deaf and hard of hearing community need relative to accountability and access to services? What about seniors, LGBTQ? The list goes on and on. How do services and demands change when we're talking about an immigrant population? Refugees. What about men who are on the victim side of domestic violence? How effective are we as a community at meeting the needs of men as victims and being accountable to that? In your packet, you have a lot of information, and a lot of it's very tiny. So we wanted to make sure you had copies of it that you could follow along with and make notes on in your own possession, because it would be difficult to look at from strictly on the screens. But we're going to start this morning with three representatives from law enforcement who are going to talk about what happens immediately following an incident and what are the options that a person has to follow. You know, how does a victim respond immediately following an incident? What are their options and what are the various paths they can follow? So there's an incident flow chart, then there's a city and town criminal court flow chart. We're going to specifically look at that criminal court process. We have representatives from the DA's office who are going to be here to talk about misdemeanor level crime as well as felony level crime. Sometimes I find at the DVC we spend a lot of time talking about felony level crime, and the vast majority of it is violation and misdemeanor, and we sometimes don't know what to do when it doesn't rise to the level of felony. So I think it's important we talk about both or all versions. There is a domestic violence incident report. We hear a lot about DIRs within this community, but what's its purpose? How do we use it? Are we all familiar with it? Why is it important? We're going to know a little bit more about the definition of family offenses and how that plays into both the civil as well as the criminal court. There's also a term, a legal glossaries term in your packet. That tripped us up a lot as we were trying to work through this. It was interesting with people from a broad cross-section of different agencies who understood some of this terminology and who was really struggling to understand it. We wanted to make sure we all had the same starting place. And then we're going to talk about the different types of orders of protection. And Willa's going to do an in-depth discussion around what's happening in the family court when you pursue an order of protection there. So that's the overview of what we're going to cover today. And again, I just want to thank everybody for being here. I want to remind everyone that this training was put together by volunteers. Took my slide away.
I'm sorry. Thank you.
And we will do our best to make time and leave time for questions, and I'll let each presenter decide if they want to take questions during the course of their presentation or ask you to hold them to the end. But thank you all for being here.
Good morning. My name is Belinda Colon, and I'm a bilingual counselor with the Rochester Police Department Victim Assistance Unit. I've been working with the department for 20 years. This morning, we're going to discuss the incident flow chart in our presentation this morning. On the flow chart that you have on the right side, there is a list of victim resources within the community that as victims of crime you can utilize. There's also a list of victim advocate programs within our community. There is the Rochester Police Department Victim Assistance Unit. There's the Monroe County Sheriff's Office. There's Gates PD. There's Greece PD and the District Attorney's Office. So all those different programs have different advocates assisting victims of crime.
So before we start, I'm terrible at standing at a podium, so forgive me. If you cannot hear me, let me know. My kids will tell you they can hear me wherever I am. So I think my voice will carry. We're going to talk a little bit about what is an incident, what defines an incident. Because there are so many different paths an incident can take or what it looks like, I think it's important to understand the definitions that we're going to use in moving forward with this flow chart, which I have to say is beautifully done by the DVC. So an incident can be something as simple as a dispute. It can be two people having an argument. It could be a custody issue, something that doesn't necessarily violate the law. When an incident happens, if it is amongst a domestic relationship, it is two people that are related by blood, marriage, or intimate relationship, they should be writing a domestic incident report. If it's not, New York State mandates a domestic incident report be written. If it's not, it's two neighbors, you're not necessarily going to get an incident report. Chances are you're not. But if it's a domestic, you should be referring your people to request a domestic incident report, at least a CR number, so that we can find it. New York State tells our law enforcement officers that they should be handing those out at the scene, so people should have something with them. It may not be completed sometimes to the way we hope it to be, but it's at least something they can have there with them. Another form of an incident is a violation. A violation typically happens prior to police getting there. So it's not a crime. A violation is not a crime. Sometimes people think it's listed as a crime. It's not. It's a violation of the law. But if law enforcement is not there to witness it, it's actually the civilian making the arrest and law enforcement just doing the paperwork. So if someone's arrested on a violation, and a violation looks like a harassment, if you and I get in a physical altercation, but nobody really sustains any significant injuries, that's what we call a harassment. Trespassing is a harassment. So a harassment or a violation will rise to a level of up to 15 days in jail. Rarely do we get 15 days in jail on a violation. The next level of next level that we go up to is a misdemeanor. A misdemeanor is not as significant as a felony, but more than a violation. So misdemeanors could be an assault third, where you and I get into a physical altercation, you have some injuries, or I have some injuries, and the police make an arrest. Now, with domestic violence, I think it's important to understand that there are crimes that raise to the level of mandatory arrests. Violations are optional. Victims have a right to say, I want him arrested, and we have to follow through with it. Misdemeanors, police should not be asking the person, do you want to have him arrested or not? You should assume that the person wants, that the arrest is going to happen. But an individual can say, I don't want him arrested, unless it's a criminal contempt. Then we get into, it's a mandatory arrest because the individual has been told that they should not behave in that manner by the court. So some misdemeanors. Felonies on domestics are mandatory arrests, so they have to make them. So we have violation, misdemeanors, and then your top category is going to be felony arrests. And those can range anywhere from E to A felonies. Should A felonies being your murders and all of that. So that's what an incident can look like, anywhere from a dispute to an A felony. So when you look at the flow chart, if you look at the flow chart in your pamphlet, there's a couple ways that an incident can go. A victim can choose to tell nobody, at which point nothing happens, right? It's their story, they're keeping it to themselves, they have the option to do that. A victim can go to family court, and I don't know if you have all had the opportunity to accompany a person to family court. The CAPS workers, the Willow workers that are up there do a phenomenal job with working with victims and making sure that they have their resources available and they're aware of their resources. They support them through it, so if you're an advocate and you can't get to family court with them, feel confident in knowing that the CAPS workers, the Willow workers down there are there to support them and do a fantastic job supporting them. The victim may choose to tell a family member, they may choose to tell somebody in their congregation, they may tell a neighbor. And those people are linked to getting supports and services for people. So especially if you're one of those people that are given that information, make sure you know your resources. Reach out to your coworkers, reach out to the victim resources that are available to you, make connections. I see some familiar faces. I don't know everybody, I wish I did, because that would mean we're even more cohesive. But it's important to know who your counterparts are in supporting victims through this process. Or the victim may choose to go to the hospital, or to urgent care, or to their doctor. If a victim chooses to go to let's say the hospital has to do an assessment for domestic violence. They have to ask. The victim doesn't necessarily have to tell, but they have to do an assessment. It's also a time where they'll do a rape kit, collect any evidence that we may need for trial. They engage them in HEAL. HEAL is counseling services that work with victims that are in the hospital. So there's a lot of services just right there at the hospital. Now, if you go to Strong has their own law enforcement officers there. They're peace officers. So they can make an arrest, but typically their jurisdiction is U of R property. So chances are that the incident didn't happen at U of R. So the medical provider would call 911. 911 would dispatch an officer to come to the location and take a report. They may also have to call Child Protective Services or Adult Protective Services. Medical providers are mandated reporters, so they do have to call. So that may be how 911 gets the call. Sometimes we do also get people that just walk into the substation, which is really hard. If you have someone that walks in, and if the deputy or the officer doesn't know enough to say where it has happened, sometimes they'll give you their whole story of their victimization, and then you find out that it happened in someone else's jurisdiction, which is really hard for people, because now the deputy or the officer is gonna say, oh, this isn't my jurisdiction, you have to go to this jurisdiction. So if you're having somebody call you and they're telling you, you know, I was raped, or I'm being sexually abused by my father, I don't want them to come to the house, I'm gonna go to the police station. Find out where the incident occurred, because wherever the incident occurred is gonna be who has jurisdiction over the case. Now, some people will say, well, Monroe County Sheriffs have jurisdiction all over the county. They do. But if it happens in a town, they're gonna refer you to the town. If you don't know who has jurisdiction, call 911. Call 911, they'll tell you who has jurisdiction, and you can help the victim get to the appropriate place to make that report. The other way of getting a call in or being referred to law enforcement is for the person to call 911 directly. And when that happens, we can talk a little, Wendy's going to talk a little bit about what that looks like. But basically, you call 911, you tell them the nature of your call, they'll ask you, you know, your demographics, name, where you live, phone number, all that. They're gonna ask you where the crime occurred so that they dispatch the appropriate person, and then they're gonna send a car out to wherever you are to get a report. Once an officer responds, Wendy will go into a little bit more about how what that looks like.
So I'm a retired Monroe County Sheriff's investigator. So when we would respond to calls of domestic violence, the first thing that we're always going to do is trying to make sure that the scene is safe, make sure that nobody's in harm's way. Once the scene is safe, we try to separate the parties. So we have a husband-wife situation that was pretty much the norm. So we try to separate the two parties. We would try to get both their sides of the story. It's really critical for the police officer that's there to make sure that they understand everything that happened. We have to identify who the primary aggressor is, see if anybody needs any medical attention. And like Mary said, we have to do like a quick assessment to decide what the next steps are going to be. Because if it's a violation of pushing, shoving match that didn't happen in our presence, we can't make that arrest. But if both parties are there and say the husband shoved the wife can technically do a citizen's arrest right there in the spot, and we can arrest the husband. And by arrest, what it would be is an appearance ticket. There's no fingerprints, no photographs, but you can get an order of protection. You can get one through the local criminal court, or you can get one through family court. If we arrive on scene and we notice that the woman, and I don't mean to pick on guys, I'm just giving you the average thing that we would see most commonly. You know, if the woman looked disheveled, or she had swelling, or she looked like she was physically injured, then obviously it's a misdemeanor. So we have to assume that an arrest is going to happen unless all of a sudden the woman says, I refuse. We were not allowed to legally ask a victim if they want somebody to be arrested if it's a misdemeanor charge. And then there's the felony. Obviously, if somebody's threatening weapons, guns, if the injury is like a broken bone or some sort of protracted impairment or something that's really significant, then it's a felony level and the victim no longer gets to decide whatsoever. I happen to love those changes because when I came on the job a little over 25 years ago, that wasn't in existence. So the victims tended to feel responsible, like I had him arrested, and then that suspect would come at them and say, you had me arrested, I went to jail because you decided. So it's kind of nice that the laws have changed in protecting the victim to the point where now it's the cop's fault in a sense. So, and as a police officer, I didn't mind having that responsibility. I'm making the decision. I'm making that arrest for you because my job is to keep you safe. So those are kind of some of the things that would go through our minds at the time we're on scene. The other things that we would look for is whether or not an order of protection was in effect at that moment. That's critical because in New York State, if there's a violation of the order of protection, whether it's a no offensive contact order or a total stay away order, if those are violated, it's a mandated arrest, whether it's a misdemeanor or a felony, it doesn't matter. So we have to determine whether or not there's one in existence. Weapons being involved. Sometimes the weapons have to be removed from the home. And then obviously children as well. So we, just like medical staff and so on are mandated reporters. So if the children witness something, or if they are in danger, or if they're injured in any way, shape, or form, we have to contact Child Protectives. So there's a lot that goes into our assessment when we're there on scene, and a lot that we have to determine before we're walking out the door. And I know in the sheriff's office is a little different than in the city, because in the sheriff's office, sometimes we can make an arrest, we can issue an appearance ticket, bring somebody down to our substation. We could fingerprint somebody, photograph them, give them an appearance ticket. Sometimes they got arraigned, sometimes they didn't, it depended. But I know in the city, their process is a little bit different, just by mere volume of cases that they have coming in every single day. But at the end of the day, our objective is to make sure that everybody is safe, and to try and make sure that we provide a safe environment for the future, so that that victim can go home and they can sleep at night knowing that they're not going to be assaulted, or a domestic situation is not going to occur again. Did I cover everything for you?
Do you guys have any questions regarding the process? You know, we know it's not a textbook case. Every case is not a textbook case, and there are many avenues that it could take. But when we look at the arrest process, I think the flow chart does a really nice job breaking it down as far as, you know, what to expect, what could be expected in a situation like that. So I think it's important to understand that, so you can help your individuals work through the process or prepare them for the process. The unknown is scarier than the known, we know that. If we can give our victims information as far as what to expect, what the process is going to look like, then we can empower them so that they're comfortable, a little bit more comfortable in knowing what to expect. And I know Sheriff's Department, just one thing, Greece right now, their advocate is out. They have not replaced it since Eva retired. So make sure if you're making that referral, you're aware of the fact that Greece doesn't have an advocate. I hate to give a referral that's a dead end sometimes. You have a victim that's finally reaching out, to give them a referral that doesn't work is counter-effective. So that's why I say reach out, know your advocates. I'm always up for a phone conversation, a cup of coffee, talk about the process. If you don't know it, we all walked into this field not knowing everything, and I think if we can help each other, we benefit from that.
Sure, can you talk a little bit about the role of advocates? For example, somebody may have chosen not to press charges, but could they still talk to you?
Absolutely. And I think it's important. Sometimes they choose not to press charges, or sometimes the charges don't raise to a level where they can press charges. So having a phone conversation with an advocate, we're embedded right in the Monroe County Sheriff's substation. There's one in each substation. So we'll talk to a person about what possible outcomes are, or what referrals there are. So even if we can't make an arrest, it doesn't raise to that level. We can refer people, and that sometimes that 5 minutes of prevention or knowledge can get them out of a situation where it may be a crime later on. So making those referrals, if we can get people just to open up that pathway and talk to advocates, we can educate them and give them a little more information about what to expect, what other resources are available, and how to protect themselves. We also work on safety plans, as does Willow down in the courts. Go ahead.
I know you mentioned how important it is for the victims to have their domestic incident reports. So what are you suggesting advocates do when victims do not have their domestic incident reports?
I would encourage them.
Karen, can you repeat the question so that we get it on video?
Yes. So the question was, domestic incident reports should be given out to victims. What do advocates do if a victim was not given a domestic incident report? You have every right to call the department back and ask them for a domestic incident report. You also, and I think the better plan of that, you can FOIL request, that takes a long time, but you can also reach out to your victim advocate and have them make contact with them and ask them the status of the report, is it signed off, you know, can I get a copy of it, and they'll help you through the process.
With RPD victim assistance, now officers that are responding to the scene have to give a domestic incident report. And also, like Mary said, also, like Mary said, with the Rochester Police Department, we get all of the domestic incident reports, and we're assigned and we follow up on all of them. So, for example, if they're not able to, for whatever reason, they can always come to the public safety building, the first floor, and get a copy. But now, when officers are responding to the scene, they're supposed to be giving them a domestic violence incident report. And with our office, we follow up on all the reports. We're in the police sections. I'm in Upper Fall and Clinton on Wednesdays and Fridays. We go to Willow. We're an integrated domestic violence court. There's also always an advocate in Part 1, Part 5, which is arraignment felonies, misdemeanors violation. We have individuals that walk into our office, that call our office, and they don't even have to have a report of an incident. They can just call us and speak to us and say, this is what I'm going through, what are my options, and they don't have to have an active case. So they call us all the time. We have a main number that they call for assistance, and there's always advocates in our office from Monday through Saturday. So we try to reach out through many avenues, through the reports, through court, them calling in, them just walking in, and just referrals. So we get a high volume of cases. There's 9 counselors with the RPD victim assistance. There's 2 of us that are bilingual. We work closely with Willow, with the district attorney's office, with other advocates in other towns. We try, because at the end of the day, we're here for the benefit of the victim. And if we all work together, we can be stronger for the victim and whatever options they have in support in this difficult system where a lot of them want to just stop because they're exhausted. They're exhausted of having to come to court. They're exhausted of having to deal with the offender. And they're just, with the whole process. I have some individuals that are like, I want to pursue, I want that order of protection, I just don't want to go to court. I'm tired of going to court. I'm tired of him being released. And they do have a point. You have to acknowledge that at the end of the day, and us being their support system is what's going to get them through. Sometimes they tell me, thank God you accompanied me to court, because if not, I would have stopped coming to court. So just being that support for them 100% throughout the system, that is difficult for them. It's a strain on them, on their family, financially, the children. It's a strain all over. But us being there to assist them, it's very beneficial to them.
I have to interject real quick. We don't follow up on every domestic incident report. I wish we could. I wish we had the ability to do so. We typically only will follow up on the more significant crimes, repeat crimes. If we see repeat victims, we'll follow up. But we don't have the time to follow up on everybody.
But the sheriff's office does issue a copy of the domestic report when they're on scene, in addition to on the back of the DIRs, there's also a victim's right form that typically gets given to the victims as well, so it gives them that added information that they may not be aware of.
Is it included, is it the full narrative are we speaking of, or just the number?
Sometimes, it just
Sometimes
depends
it's not.
on, if the officer can stay there and write it out, great, but sometimes there's another call that's coming in, the scene is safe, everything that can be done has been done, and then they have to leave, so they might just write the gist of it, but then later on, they may add to it in an addendum, which is a second page report that the police officer may write.
Yeah.
I just want to add that just because you don't do outbound outreach to every victim in the county, through the sheriff's department, any victim can call you. It's
And-
not that you're not available
Nope.
to them, it's just that you can't be proactive in every
Right.
case.
Did you have a question, sir?
Yes, is there a summary of the reports that gets published to court or probation? Names of the victims or the perpetrators, as well as the incident numbers?
We do a daily and a weekly report for each zone, and then it goes into coordinators, and the coordinators has all the different departments. I don't know if is it published?
I don't know, it's publicly, it's like
Yeah,
not
it's
that,
not
like
out there,
it's,
like you can't go on the web and say.
No, I understand that.
but like at the zones in the sheriff's office, we would do roll calls every single day at every single shift, and we talk about different incidences that have happened recently. So if we see like a common occurrence, we sometimes will ask OEC 911 to like put an alert on a specific house where we feel there's a heightened danger, where there's some threats of weapons or something like that. So we're constantly in communication with one another in our particular areas to make sure that the officers know what's going on and a house that may have consistent troubles.
So it's important for the jurisdiction then.
Absolutely, for officer safety and for victim safety. Any other questions?
Yep. All right, well, thank you for listening. My number's on here, if anybody has any questions, for anything, any law enforcement victim assistance questions, feel free to give me a call.
My name is Bill Gargan. My name tag falls off immediately when I put it on my back pocket. So I, along with Ann Chase, work at the District Attorney's Office. And I can tell you that I'm the Bureau Chief of the Domestic Violence Bureau.
And I'm the Bureau Chief of the Local Courts Bureau, for City Court and the Town and Village Courts.
So what I get to focus on is the felony cases that come in to our office throughout Monroe County.
And I do all the misdemeanor violations.
I don't know if I'm supposed to stand the entire time, so I'm gonna sit down. I thought I'd just introduce myself standing up.
They're gonna talk primarily to what's on the purple piece of paper in your packet, so I apologize, I thought this was gonna be on the screen, this is just a logistical mistake on my part, so you guys are white, but they're still purple.
All right, I'll start out with Rochester City Court. In Rochester City Court, if a misdemeanor or a violation is brought, it is brought to the Part 1 judge. They sit for 1 month. We have 9 judges in Rochester City Court, and they each sit for 30 days, approximately a month term. So the Part 1 judge takes in all the misdemeanor violation cases. And what happens at arraignment is the case is, the DA gets the case and processes it in the morning, and then the defendant is arraigned. They plead not guilty, they're assigned an attorney, or they indicate they want their own attorney, and then they can, but they're always arraigned at court in the Part 1 on that date. And then if they wanted to bring in their own attorney, it can be adjourned to another date. At the first arraignment, though, is when we ask for orders of protection. The judge, today, up till January 1st, can either release the defendant on their own recognizance or send bail or release their pretrial services. But after January 1st, there really is no bail. The defendant judge would have to release the person because there's the change in the bail statutes. So after the person is arraigned, they set a next court date. We provide discovery to the defense attorney, which is all the police reports and the paperwork we have concerning that case. As of January 1st, we have to provide it within 15 days and certify that we've provided everything to the defense. So the next part will be a pretrial conference. The DA will review the case, speak with the victim, and come up with a proposal, an offer. We'll convey that to the defense attorney, then we'll have a conference and convey that to the judge. And if the defense and the defendant agree to what we've offered, then it would be put down for a plea. If they decide they're not going to accept that offer, then the case would be put down for motions. And after the motion arguments, if there's hearings required, if there's evidence that needs to be suppressed, then they do hearings. If there's no evidence, like on a case involving domestic violence, usually with a criminal contempt, there isn't evidence, so they just put it down for a trial. A defendant has a right to either have a jury trial or a bench trial. And if they choose that they want a bench trial, they sign a waiver saying that I'm waiving my right to a jury trial. We have no input in that at all. So it will either be a jury trial or a bench trial. And the options are either once you go to trial, it's either guilty or not guilty. So after, say, we make an offer, we have many ways we can make an offer. They can take a plea, or we can offer an ACD, which is called an adjournment in contemplation of dismissal. Sometimes victims, people just don't want to go forward with it, but they want to order protection. They want to make sure the person, they just don't want to proceed with it. But that's one way we can do conditions and say, you need to get treatment, you need anger management, we can still get you an order of protection. So that's one way that we talk to victims about, how you can proceed that way if you are adamant about not coming to trial, but at least they have something over their head. If they violate an ACD, an adjournment in contemplation of dismissal within 6 months or a year, they have a right, we have a right to reopen it if there's good cause. So we have done that in the past. If someone is convicted, we have many options. If they plead guilty, if they decide to take a plea to a criminal charge, or they're convicted after trial, they have a right to, we can sentence somebody to probation, we can sentence somebody to jail and probation, you can get a conditional discharge, and a conditional discharge would be for a year, and then we can place conditions on it, like getting treatment, getting drug treatment, community service. We can ask for an order of protection for 5 years, depending on the charge. We can do many types of counseling. There's lots we can put many conditions on a conditional discharge, or ask through probation that they be treated a certain way. Mental health services, letters of apology. I mean, we basically talk to the victim and see what they're looking for, restitution if there was damage to any property. In the towns, when they're town or village courts, the DA isn't always at arraignment. But when there is, say, a criminal contempt or domestic violence type of case, the defendant would be brought before the court, and an order of protection hopefully would be issued by the court, and then they would most likely be released, especially after January. They're going to be released. And then it proceeds the same manner. It would be adjourned to the next court date, and then we would just proceed on, talk to the defense counsel, and have discussions with the victim and see how they want to handle it.
Can I ask a couple questions? And just so that we get it on video, can you repeat once I ask what the questions are? Can you just talk a little bit about your role as a district attorney and who you're representing, right? Because you're the state, not the victim. So
Right.
how is that explained, and what, it's really confusing for a lot of victims.
Right. It is confusing because technically we represent, it's the people of the state of New York against the defendant, not the victim against the defendant. So a lot of times people feel that we're their personal attorney, and we're not. What we're looking for is to do, what we look to is to do justice, what's the right thing. Sometimes when victims don't want to go forward, and we see that we can prove it without the victim, and we see the history, and we understand the domestic violence past of this person, and we understand that people are scared, and they're dependent for economically maybe on this person. That we try sometimes to, and many times, if we can prove it without the victim, and we've done that many times, if we call a family member, or see if there's a witness, the 911 call, we can do what's called evidence-based prosecution for their own protection, because we've had a person come to the office angry, why are you doing this? I don't want to do this. But we're looking at the bigger picture, what's right, what's just, and to protect the victim, even if they don't want to be protected at that time. And we also recommend, like Resolve, to go to Willow, to reach out for help and try to steer them that way for help themselves to get some support. Because we see the same people and the same victims and the same defendants over and over again. And we do what we can to try to prosecute it, even if they don't want to prosecute it, and they do get angry at us. Now, sometimes we just can't. If it happens in a house and they're the only two people there, and nothing happened outside, and You know, it's like, I had one woman come to the office and say, I want to drop all the charges. And I'm like, why? I said, you called the police for a reason. There was a reason you called for help. She goes, I didn't call the police, it was my neighbor. It must have been when they saw the blood. And she just wanted to drop it, but unfortunately, I mean, so, you know, we look into that and to see, what did the neighbor see? Is the neighbor willing to come forward? What did they observe? What is the 911 call? You know, so, but people, they get angry sometimes, but we try to explain we're the people, not your personal attorney, and we have to look out for what's right.
You mentioned in that, which was very helpful, past, like an awareness that you have when you've seen multiple charges concerning the same family, the same, or sometimes the same offender with multiple victims. How does that past play into your process? Because can it, or are you looking at each situation individually?
No, I'd say we look at the past, we look at the defendant, we look at the past, and we can pull up who the victims are and how many women. And this also affects, it can also, based on their past, can become an aggravated family offense, which Bill, we take it down. If we see that there's a pattern in abuse, we take it down to Bill, and Bill will look at it and see if we can do an aggravated family offense, prosecution as a felony, and we get the certificates of conviction, and we can, you know, sort of build a family case, and then Bill would take it as a felony. But, so we work in tandem. The misdemeanor violation, you know, and local court, we work with the felony bureau. We're very close. Luckily, they're on the second floor, we're on the third floor, so we're up and down all the time, talking about it, asking for help. What do you think? How should we handle this? But we definitely look at people's records and their past to assess what kind of offers do we want to make? Does this person have a history? We can tell, and then sort of, do they need probation? Do they need jail? I mean, so looking at their past helps us figure out how we want to handle this case.
When you discuss looking at the past, are you looking at the past with that one particular victim, or can it be a past of domestic violence history with other victims?
It can be.
We see across the board.
When we're looking at a case, we can look in our computer system at the whole person.
Okay.
And we can see past victims and the nature of the charges and what's happened with those charges. So we have a lot more information at our fingertips that we can look at and sort of assess it and build from that what kind of offer we want to make and how we want to approach the case.
And you mentioned that the victim, you do try to talk to the victims, and if they choose to be participating in the process, can they contribute what they would like the outcome to be? Can they give you their input and their thoughts on that?
Definitely. We want to hear and ask them what they feel and how they, now sometimes they're not realistic about what they're looking for. I mean, most people want to send, like, you know, some people are so angry, you know, prison, you know, but that's not an option. And knowing sometimes our judges too aren't going to accept our offers. So, you know, you sort of have to look at the judge, the case, the person, and try to explain how the system works. We like to have people come in and meet with us, especially if we're heading toward trial, to come in and talk about it. Sometimes, like, charges will get dismissed initially, like paperwork isn't, like we just had one, a DA this morning, just before I came over, an order of protection was served, but there was no affidavit of service attached to the paperwork that was filed in the court, so the judge dismissed it because we have to show the defendant knew there was an order of protection in place. So we did get the order, we did get the affidavit of service, so we moved to refile everything. So we refiled the paperwork, a new accusatory instrument, and we're starting from scratch with that. So we do, you know, work on it and talk to the people, you know, everybody. We try to have people come into the office and discuss it, especially if they're very confused. Or sometimes we have to add charges. It starts out one way, and then we talk to them, and it appears, it might start out as an harassment, and then they have medical records, and they show us it's really an assault third. So they'll come in, we'll talk, we'll have them fill out a new deposition, and we'll refile the charges as a higher charge. Yes?
What What is the rationale for the bill requirement being removed?
You'd have to ask the legislature about that. It's coming into effect in January, and it's gonna be momentous, I think. It's gonna take the judges, it appears I've gone to some, training on it, and the judges were given some training, and it's gonna be very complicated. If they wanna add like something other than an ROR, they have to articulate their basis for upping the restriction, like pretrial services or setting bail, and they have to write it down as to why they're doing it, and every time they want to go to a different level, they have to explain it and set the record, articulate why. It's going to be interesting to see what happens, because it's a whole new world, starting in January.
Can I ask by show of hands, how many of you professionally or personally know somebody that was a victim in a criminal case? Just by show of hands. And let me ask you, have you talked to those people about the process? And how many of you, based upon the feedback, and if it's more than one that you've had, did you feel that that victim felt that it was a positive experience or a negative experience? How many would raise their hand and say, by and large, the people that you knew felt it was a positive experience? So I want you all to look around. All right. How many of you believe that the people that you spoke with felt it was a negative experience? Okay. So you realize that we have a process now that's extraordinarily difficult. It's difficult to have a victim feel that it worked for them. It's difficult for us to reconcile our obligations to represent the people of the state of New York, and yet hear that voice from the individual person. And plus, it's just difficult. It's hard. When I pick a jury, I ask, how many of you like public speaking? Very, very few people. I'm gonna ask you, how many of you like public speaking right now? Okay, all right. Maybe I got some lawyers. But again, guys, I want to see, there's not many people that raise their hand. Then I sometimes ask, okay, how many of you like to talk about a horrible, intimate incident in your life in front of strangers? How many people would like to do that? Oh, and also about that, yeah, it's about a person you chose to have in your life. You figure like the most important choice of your whole life, who you want to spend it with. And if you make a mistake there, or something bad happens as a result of it, sometimes you feel like you failed. So it's horrible. And I'm asking people, hi, my name is Bill, I'm a stranger. We're meeting now because something terrible happened to you and it's on my desk. And I'm asking you to trust me as we go through this process. That will inevitably be complex. That will inevitably involve emotion. Because you're not going to look at somebody and say, for the most part, all right, I really want to move on completely and wholly. I can tell you, in the back of the room right now, Mary DeLella is there. She worked on a case in particular with a woman who was horribly attacked in the middle of the daylight in a western suburb, in which 2 Good Samaritans stopped as she flagged them down in the middle of the day on a road. This assailant broke a bone in one of the assailants, one of the Good Samaritans, then jumped into the car of the other Good Samaritan and tried to drive over this woman. Horrible. I can't tell you the amount of time Mary spent with this woman who really still felt that this person should be in her life. He's in prison. He degraded many things involving her, mentally, emotionally, physically. And yet she still felt, I really want to see him. It was very hard to move on. The victim advocates that you heard, and law enforcement you heard earlier, we work hand in hand to do the best we can. But it's an imperfect system. And if we're tasked with trying to protect everybody, I mean, sometimes I'll say, I know that you don't want to cooperate. But what I don't want to do is meet the mother of a daughter who's killed after you. So do you understand why I am asking for your help here? So I can tell you that if there's a felony arrest, what I'd want to let you know is that's the beginning. It's the the beginning. Since it is an intimate relationship, you know what usually happens by the time of the arrest until the time it gets to my desk? There is contact from the defendant's family with the victim. Oh my gosh, you're gonna send him to prison for 7 years? Because immediately, they'll look at the charge, and they'll see what the maximum possible sentence is. The victim's like, no, I never said anything about that. He just, he cut me. Oh, he's gonna go to prison for 7 years. Well, I don't wanna cooperate. And then we'll get the case, we'll call the victim to immediately find out when we can, I really wanna go forward. And you're thinking, what happened between now and then? So we have to be sensitive to find out what information is being given to that victim. And then we can always share about, well, that's not gonna happen here in this case. And I say that because it's very, very rare that somebody's gonna get the maximum sentence. If you're getting the maximum sentence, that's usually a lifetime achievement award. Okay? That means you've done so many things so badly that you've given us no other choice. But that is really rare. Right? I mean, you're not gonna get that. So you try to kind of engage. And again, I love what I do. I basically ask people, what can I do to help? And that's an unusual posture for some people to get asked. Because they don't know what's available. So you have to advocate what causes the problem. And you try to engage as best you can. Now again, everything is viewed through the matrix of the quality of the evidence that we have from our law enforcement partners. We also realize now that when the case begins with the arrest, we still go and try to find more evidence. And look, I'll tell you, one of the biggest assets we have is to ask and learn about people in that victim's life. I will candidly tell you one of my secrets. When I meet a victim, on the phone generally, I'll ask, if you lose your phone, or if your phone gets stolen, how can I get in contact with you? Usually that person will tell me the other most important person in their lives. Sister, mom, brother, girlfriend, boss. Then, if my communication breaks down, I can reach out to that person. Say, hey, I haven't heard from her in a while. And I can get some feedback. I remember talking to one woman and said, well, he broke her ribs when they lived in Ontario County. No, I didn't know that at all. She didn't share that with me. When you have a felony arrest, it's the beginning. And our goal is to learn what to do next. We have a lot of options. If we're going to go forward with the felony, there are certain things we have to do. If it's a felony, we have to go to a grand jury. A grand jury in New York is something that happens in our state. It doesn't happen in every state. And what it is think of it as a buffer between the power of the state and an accused person. So you have 23 civilians that hear evidence. And they get to determine, is there enough here to go forward with the felony case? Because you don't want somebody accused of a crime sitting there, let's say, for months, when it turns out the evidence isn't there. So you begin the process by going to the grand jury. The defendant isn't there, the defense attorney isn't there. And I share that because sometimes it's very difficult for people to even want to get in the same room as somebody. But then that begins the process of getting to the next step of a felony prosecution. The judge is going to review what we did there, make sure that we were professional, that the grand jurors got to ask questions that were appropriate, that the evidence supports the charges. They're going to review everything that's said in that. And then we'll begin that felony prosecution. And again, I can tell you that the next step after the indictment doesn't mean that it has to stay at that level. It's a wide variety of options that can occur. Now, I also want to share with you a follow-up on the question you had earlier and what Ann Chase talked about. So if you think of all the activism that is potentially in this room right now, and think of all the activists who were in the past, their voices helped to change law in New York State. Just completely fundamentally change the law. Every law enforcement agent in the state has the ability to have discretion as to whether or not to make an arrest, except for one area. That area is domestic violence. Because repeatedly in the past, there were instances in which an officer came to a location, the victim's got a bloody nose, defendant's there. Do you want him arrested? It's just no. The officer says, okay, walks away. You know how many people like you it took to kind of go, there's a reason why she said no. maybe he said, I will kill you and the kids, you know, if I get arrested. Now, I don't know how many of you have kids in the room, but you know if you have kids, you start reading about things you never paid attention before. You know, because of what I do now, what I've done for years, you know every time you read about a woman that's murdered or missing, you know what immediately goes off in your head, right? And you know how saddened you are when it proves true over and over and over again, that it's the partner. I mean, that's a terrible statistic that happens over and over again. So, what we do is to try to empower people to understand what we're doing, to listen to the voice that they have, to let them know what the process is. Like, and I'll still tell you, I can't make the process of getting into a room and being cross-examined easier, except through trying to prepare somebody for it. And my usual advice is, you've survived the worst that could happen to you. You'll be okay here. My victim advocate will be in the courtroom. You can have somebody that you want there. You can look at me, take deep breaths. I can bring you to the courtroom. You can see what it looks like. You can work on that. It's hard. One of the things people like you did was change the law, so we have something called an aggravated family offense, which is where when somebody commits a misdemeanor, they've got a history of a conviction within the last 5 years of doing it to somebody else in their family, you can take that and turn it into a felony. It's a tool we don't use all the time, but it's a tool that's available to us because when you had somebody who would abuse one girlfriend, or one boyfriend, and then go on to the next person, there was that sort of absence of accountability. And it's a tool we use. And we'll have prosecutors that will be trained to share information with us so we can do that. There's another great statute in the books. Does anybody remember when strangulation wasn't a crime? Wasn't a crime. We have two. We have criminal obstruction of breathing and strangulation. And the law enforcement agent would get there, and really they were focused on physical injury because that's what the law was. Is there physical injury? No. You didn't have the threshold of physical injury. You had people that felt like they were literally going to die. And so it took people like you to kind of say, you know what, this needs to change. So we have a misdemeanor criminal obstruction of breathing, we have the felony strangulation second, strangulation first. So, you know, activism can be creative in helping address the law. And what we consistently try to do is develop a path to get people to trust us. Because they may not be ready yet. So you realize, you know, generally if somebody gets their car stolen, it's not gonna happen again and again. You know, I may not be ready to cooperate right now with the person that stole my car. Usually there's no problem. But somebody maybe really doesn't want to cooperate. And every victim is the expert in their life. They know everything that I could never know. And so we may not be able to meet them now, but we can kind of be partners in listening and letting them know about our resources in the community. So maybe later, they want to cooperate. And we've had those. I know you've probably seen them too. The person may not be ready yet. I can also tell you from our perspective, we will sometimes ignore a victim's wishes. I'll be candid with you. If we have somebody that we truly believe warrants a conviction for the betterment and safety of the community, and we can do it through another person, we're going to do that. I mean, I'm working with a mom right now who's the best. Her daughter has several children with her abuser, and their lives are so intertwined. But I can prove some cases with mom. And so that's the route we're going to do. When you look at the chart as to what we're doing with felonies, you're going to realize there are different paths. Remember that, it's the beginning. So if you have a victim feel reticent, like, oh my gosh, I don't want somebody to go to prison, please know that it doesn't have to happen. There's so many different options we have. And sometimes it's going to take information for us to determine should it be a more serious or should it be less. It's a process that we consistently engage and change. And we're going to have bail reform, so we're really going to have a different place come January 1st in terms of the conversations we have. Because typically the thought of, okay, the person's going to be arrested and they're going to be in jail maybe for a few days, that's going to change. So safety planning will be different. Expectations will be different. I always fear when victims go, they didn't believe me, I guess that's why he's out of jail. No, it's a process that's going on. So, I asked each of you when I began, how many of your experiences with victims were positive ones? And nobody raised their hands. So you know what we have to do? We have to try to educate as best we can to make it an experience that, if it isn't as positive, is less negative than it can be. And so, one of the things that we try to do is really just make sure we listen to people like you.
Thanks, Bill. I think one of the challenges is that the vast majority of cases are that lower level court. So we don't, ADAs have a ton of cases. And while clearly the intent is there to do the best that they can to connect with every victim and understand what their wishes are and engage them in the process, not always, I think those of us sitting in the room who are working with them often hear that victims feel like they don't get the support or the service they need at that misdemeanor or violation kind of level. So, you know, what can we do to become educated ourselves and support victims who are pursuing the process or it's being pursued against what they actually want?
Okay, I know there's a lot of frustration too, because in the local court level, the town and village courts, the attorneys that handle those cases, one, are right out of law school. They have very limited experience in life. They basically, all of them are quite young. So this is all brand new to them. And like the ability to understand what it's like to be a victim or to be empathetic toward it, it takes time and it's hard. So, and I know it's frustrating with phone calls because they're in court all day long, and they have over 600, 700, 800 cases apiece. There's no, we don't have any paralegals or anything to assist them, so all the discovery, all the paperwork, the court time, I mean, I know they're in court because I sign their sheets. They put in 134 hours, you know, and they're there till 10:30 at night. They're on weekends. You go in, they do their best to connect. I know there's a lot of frustration because I get the phone calls from victims say, I've been calling, I'm leaving messages, nobody's calling me back. And so, you know, we do our best to help and to call, and I talk to the DAs about it. But there is, I understand there is a lot of frustration there, and we do our best to connect. We try to get people associated with, like, victim advocates, with the Sheriff's Department and RPD, to help be our, you know, conduit and to talk to, and so they can help explain, because it takes more time to explain the system than the DAs really have to be on the phone, because they're really not there, and they can't take the time that a victim really needs. Now, it's easy when they call me, and a lot of times I'll have them say, look, call me, I'm a person who's here, I can take your call, I'll be, you know, I'm there. I'm not in court every day. So, but it is frustrating, and there's not a lot of answers to it, but I think I know we refer to agencies to help us with it.
I know there's responsibility and duty for speedy trial, like, across the board, right?
That's gonna change too.
So, right, but what, right, in today's world, on a misdemeanor level charge, is there a time frame that is typical? I know everything is different, but is there a typical time frame from the point of arrest to the point of decision on a misdemeanor case?
Well, it's usually, we have 90 days to prosecute a case, but a lot of, there's times that stop. If they get arraigned and if the defense, they agree to adjourn it to a conference, that stops the time. They waive their time, and then there'll be motions argument, that stops the time. So it can go out for as long as the defense is agreeing to discuss the case. I mean, unfortunately, we have towns that have cases pending from 2017. They just don't move their dockets very quickly. But in most of the courts, they try to move them quick, you know, faster than that. So within the year, we should resolve them. Violations, harassments are tried very quickly. There'll be arraignment, and then basically set it down for trial within a few weeks. But misdemeanors get state court, they have parts 1 through 9. And so it processes through part 2 is conferences and violation hearings, and then the next month, they may do like hearings, and then the next month, then they'll do bench trials in a couple of parts, and then jury trials at the very end. So it just sort of is a process of month to month, so it could take a year per case to go through, depending how the discussions are. But it is frustrating, I know that, because I've spoken with a number of victims, it's hard.
Yeah, I think understanding that time frame, because it feels like forever.
Yes.
And then the perception, to Bill's earlier point, of how many people are satisfied with the
Right.
process, is that nobody really cares.
Right.
And it's really a process issue more than a commitment issue, it's a process issue.
Right, and it is hard because the DAs really don't have a lot of time to spend talking. And a lot of people want to explain a lot. Now, if we're going to trial, we're definitely going to have the victim come in because we need to talk about it and how it's going to be. But that's way late into the process. So it's very frustrating. I wouldn't want, and then you have, attorneys, like, there will be, I know the defense a lot of times will send investigators out to talk to the victim, and they sort of give a, like Bill said, they'll say, oh, well, you don't want him to go to jail for a year, do you? You don't want this to happen to them, and it's like, we try to advise that you can talk to anybody you want to talk to or not. You don't have to talk to us, you don't have to talk to anybody, but make sure you understand who you're speaking to and why they're there, to make a decision. Because, we've had some people say, well, you've already been out here talking to us, and I'm like, well, we'll say, no, we haven't. So, but it's very complicated, and there's a lot of people involved in the system, and it's hard to explain it. But especially in the local court level, we don't have the luxury of time to really explain everything to everyone, as it should be.
Like I say, if you have an occasion in which you have somebody who's in the process and you feel that there's a level of frustration, you can let them know that there's always a supervisor. There really is. There's always a supervisor. So if somebody's feeling, that there's difficulty here, they may not know that the prosecutor they're working with is going to be on trial. And if they're going to be on trial, it's going to be very difficult for that person to get back to them. And then, of course, the week before the trial, they're going to be preparing for that trial, which means everything's going to focus on that one case. But there's always a supervisor. So I want you to encourage them to realize that there is a way to kind of just literally call the DA's office and go, hey, can I call, the ADA's name supervisor? And they're going to patch it through. And we do receive them often. And there are ways that we can engage with people to let them know where we are with the process. Also, a lot of the times, let's say with felonies too, we're trying to gather as much information as we can. We're going to work with law enforcement as to what they've collected. Then we're going to see if there's more evidence that we have out there that we haven't collected yet. By having more evidence and more information, we can do a better job with the case. Because as you know, we're always going to engage with the defense attorney. We're always going to talk about the case. Because the defense attorney is going to be the expert of the defendant. They can share information with us. It's exactly the way you want the process to go, where you're engaging and listening in a mutual way to determine if there is a path that can allow this case to resolve. That would make each person feel that they've gotten something that they wanted out of this. Plea bargaining is really something we do on a routine, general basis. Now, again, there are some cases that are not going to warrant it, and those are going to really be self-evident. But there are going to be others in which it really makes sense. And we found that courts very much appreciate when you do that. Courts want to see that there is communication by the attorneys there, see if there's a way to resolve the case. And again, it's where you're going to look at that criminal record of the person too, to determine if it is appropriate as to how you should go down a certain path. But I really want to let you know that when you engage with the victim, that victim really does have a voice. It may seem that they're incapable of getting that voice heard, but I can promise you, we can't do anything without our victims. We really can't. We don't have the power to convict anybody of anything without people testifying about what they know. One of the ways I can always share with the victim is to say, you know that I wasn't there when this happened. So I need to learn from you what happened. And I can tell you what the police officer wrote or what the neighbor wrote, But I know that they're not here with me right now, so share with me, what can I do to learn about the case? But you realize the conversation we're having here is one that goes across in every community in our state, but every community in our country as well. And you also know, though, if you were doing some research, that 30 years ago, 40 years ago, it was starkly different. Those voices weren't heard as well. The response from law enforcement wasn't as strong. So I am exceedingly optimistic that we can continue to develop networks of support for people, so the process is one that really kind of takes into consideration public safety and the victim's needs. And I guess I also try to think that, you know, we become people that become advocates for the resources in our community. You know, we're trying to talk to people about how can I help you? You know, letting them know about places that can be supportive of them. You know, that's different. Somebody gets their car stolen, you're really not talking about, you know, a good car repair place. You know what I mean? You're not talking about, hey, you know that saw needs a little work. You know what I mean? Have you thought about going to a good garage? You're not talking about that. With domestic violence, you are. You're talking not just about the criminal charge, but who is supporting you? Who do you talk with? Do you know about the agencies that exist in our community to help you? Do you know that there are things that were done to you that aren't appropriate?
I have to say, from my experience in being there 20 years, that Bill and I have worked closely on domestic violence cases, and it makes such a difference to have that advocate reach out to the DA's office. I've gone to court sometimes when the victims are like, they haven't called me back, and I explain the process and how busy they are when they're in part one, what happens, and just be getting that information from the ADA and just bringing it back to the victim. They're like, okay, the ADA couldn't call me, but at least you called me. Or if they call me, I'll say, well, call 64 records to see what the next court date is, and then we'll try to find out and see, you know, what's going on with the case. So we work closely, and at least if we get a lot of calls sometimes, they're saying, the DA's not calling us back, and we explain, like Bill said, the process to them and how tied up they are in court. But the mere fact of us interacting, you know, makes them feel more comfortable that, okay, at least you're communicating with the district attorney. Or sometimes, worst case scenario, if they're that busy, I'll say, you're always welcome to go to court, you know, 15 minutes before it starts, and talk to them briefly if you're not able, because some of them will say, I called, and I also make that offer to them. Now, I'll tell them they can briefly talk to you, they can't hear your whole story, but you advocating on that part makes them feel more comfortable, because it is hard to get through to them. Sometimes I'll leave voicemails and I won't hear anything, but I know that they're busy, or try to send an email. We try to work together so that, you know, they know that at least they're acknowledging their case and not ignoring it. So we work very closely, and the cases that I have, it makes a big difference, even if they don't reach out to them. For myself, if I have to go to a court and say, hey, I have this case, the victim is calling me, you know, can you give them a call, or can you give me information I can bring back, then we try to work together that way, because I know they have a heavy caseload. I used to intern in the DA's office too in their SAFE program and help with the discovery, the reaching out to victims, and it's very intense. It's a lot of work. And then being in court on top of that, it's very intense, so. But he's awesome. Him and I have worked closely on domestic cases, so.
Can I ask anybody in the room here, what do you wish you could magically change? I mean, let's everybody throw it out there. Come on, if you guys have known people that have been in the system, what do you wish, you're like, all right, I don't know if it's feasible, I don't know if it's possible, but what do you wish you could change? Anybody that can throw me 3 ideas?
The president.
Just about domestic violence.
Whether it's training, whether it's in our high schools, our colleges, mandatory courses, you know, differences of, you know, what's going on. And don't let situations spiral that you can't fix them. Given that you can get them before they can fix them through counseling or something of this nature.
I completely agree with you. I often feel like I work in an emergency room. I feel like I work in an emergency room. Like if I've got the case now, something bad has happened, and I wish I could engage. And I think I think we do as advocates to try to make sure we're increasing our education. I mean, like, I know how that Ally will advocate. I know how other members of our community will advocate. So you're hoping to change the trajectory of somebody's life, to realize early on, this isn't the way I should be treated, or this isn't appropriate, to divert them from the relationship that will in turn abuse them.
There has to be a huge amount of data out there to sit there, why some people have it, some people do,
And again, the mysteries in the human heart, though, have been enormously stubborn regarding making decisions that can hopefully not result in criminality. Anybody else got any, just throw something out, there you go.
Well, it's probably a pipe dream, but that the victim, survivor, not have to testify in the courtroom with the perpetrator present.
So that gets to the bedrock of being able to confront your accuser. So it really is something that is extraordinarily rare that you could have that. It is one that is sometimes employed for child victims, but it's exceedingly rare because the essence of the criminal justice system is being able to confront your accuser in court. And so you have the defense attorney capable of doing it. So I can tell you, which is even more extraordinarily difficult, is sometimes a defendant, an accused, can say, I want to represent myself. So that's the person that is actually cross-examining the defendant, the accused that is alleged to have committed the crime. So I will say, I will entertain all pipe dreams, but I do know that one would be a significant challenge. Because again, if you put yourself in the shoes, if you were accused of a crime, you would want to have the ability to have your attorney to be there as you cross-examine that victim. So, okay.
Piggyback a little bit on what he said. I think that what we hear most is that victims feel re-traumatized through the course of the system. That the way people are interrogating them, from that first responding officer to the way sort of the judge may make a statement when sentencing is being handed down, that the entire system feels re-traumatized. I'm not sure that victims walk into court systems. I think a lot of advocates, especially now, do a really good job of trying to help people understand the reality of the situation, that no one usually walks out of the legal system feeling like, yay, I won everything I wanted. People usually walk out feeling like beat up. This was hard. From the people who are in the courtroom to the victims who are walking out, even to the accusers who are walking out. Everyone walks out feeling a little bit beat up. But I do think that it would be a fabulous thing for people to have some trauma training from level 1 to the very top, including judges. You are very empathetic. You understand why someone stays. You can speak to that because of your experience and because you just have an empathetic nature. But not everyone that a victim comes across is having that same response to them. And so what we're finding is people who are just re-ravaged by the system and who aren't able to come in and testify because the last 3 people that they talked to, they feel like they were in the room with their abuser and their abuser wasn't anywhere near them.
Yeah, and I can't agree with you enough about that. I do know that it's a consistent effort to train people that are responding to reconcile how the necessity of having somebody readdress something that was traumatic will impact how that person then is capable of responding and factoring that in when you have to do it multiple times. Because the way the system is set up right now, you're going to engage with, let's say, 911 or a witness. You're going to engage with the responding officer. You're maybe going to engage with another officer, maybe an investigator, then a prosecutor, then a victim advocate. There's so many ways.
And right now, training's a choice. So for most of the people who are engaging in training and who are getting what they need from the people who are teaching it out in the world, it's a choice. It's not mandatory. Everyone who's connecting with a victim of domestic violence should mandatorily have to receive some level of trauma-informed training. That's my position.
We're closing in on the end of time here, but I just want to say, magic wand, if you would. I think part of the challenge with domestic violence is that
traditionally, there's always been an apprehension about ever having mediation or restorative justice for domestic violence because of the fear of ever having to put someone that doesn't want to be there. And if the option exists, sometimes there's a bullying aspect of it to force people to get in there. And it's hard, but I perfectly understand the need to see if there are other avenues that can be utilized for it. So, all right, I'm gonna leave you just one, my little pipe dream, is that okay, before I go? So, does everybody know what the Red Cross is? Like, everybody's heard of it, right? I wish there was a domestic violence Red Cross. Okay, because if you live in a community where you don't know, I mean, you think about it, like, we have all these great resources here, but it's like there were no chain restaurants. But like, you have no idea, like, where am I gonna get some food? What if I go to this area, who's gonna be this resource? I wish there was a domestic violence Red Cross. So no matter where you live, you knew where to call. You know, where you knew if your sister was in a bad relationship, you knew who to call to get advice as to how to help. Where it was ingrained, when you talk about training, you talk about letting people know, you wish that you knew, no matter where you grew up in any part of this country, you knew that there was a place to go for this, because you all know the volume of incidences of domestic violence that exist. You know how it destroys families in many different ways, and you know how it's preventable. So, that's my wish list. I thought I'd throw it out there. If somebody can make it happen, I'd appreciate it. And again, so my name is Bill Gargan. I'm at the DA's office. My co-anchor, Ann Chase. And you know, you can always contact us. And I have to shoot back to court. I wish I could stay longer, but thank you so very much.
Thank you.
We're taking a break now instead of after the next segment. We have a technical issue. We have to do 10 minutes, please.
Programs, which are typically defendants who are out of custody, their case has been pending, and the district attorney and their attorney and the judge get together and they're trying to decide what they would like to do with the case, whether they want to prosecute or whether they want to divert the person. Diversion programs typically mean that the defendant's going to take a plea or have the charges dismissed if they successfully complete the program. Pretrial services here in Monroe County started in 1970, still active today. Began out of an outgrowth of the bail reform movement in the 1960s. So if you think about the 1960s, what was going on in history, a lot of people were being arrested. There was a lot of protests going on. A lot of those individuals that were being arrested were indigent clients that were a minority. They were ending up in jails across the country. At a federal level, there was some bail reform committees going on, and they wanted to take a look at what they could do to try to alleviate jail overcrowding and address the issue with regard to our United States Constitution that says individuals have the right and responsibility to have their bail reviewed. We actually began here in Monroe County under a pilot project of the Junior League. Has anybody heard of the Junior League?
Yeah.
So there was a lot of influential people here in the county. Many were attorneys' wives who wanted to do some pro-social activities here in the county. They had looked at what was done in New York City, and New York City had begun the process for the first time in the country of pretrial of evaluating defendants, asking judges to then release those defendants and measuring whether or not they would come back. New York City found that most of the defendants who were released, who had community ties, who lived within the New York City area, would return to court voluntarily. Again, we are supported by a contract with Monroe County and a grant from the New York State's Office of Probation and Correctional Alternatives. So what is our process? Our staff go in 6 days a week. They interview all defendants who are scheduled for arraignment, usually within the next 24 hours. That easily happens in city court and town courts, as Ann alluded to. There are about 26 towns across Monroe County, and all those individual judges arraign people throughout all hours of the night. Obviously, we do not have the staff to be in all those courts, so we see defendants for the town courts when they're sent to custody and they're being detained. Our staff goes in and they do a risk assessment, especially with regard to the new law. You'll hear the new law talk about the use of risk assessments across the country, across this New York State. The risk assessment really is geared towards taking a look at a defendant and deciding whether the defendant, based on certain factors and questions that they answer, are a risk of flight. That's the first issue that many people, especially domestic violence charges, may have with regard to bail, is that New York State is one of, I believe, only 4 states in the country that still do not have in their bail statute anything regarding dangerousness or whether they are going to be rearrested once released. Bail really in New York State is whether or not the defendant's going to return to court and whether or not the defendant ensures they'll be returned to court. So our risk assessment has to be, at this point, geared towards the law, which is what factors can we assess a defendant and decide whether or not they will return to court. The staff interviews the defense, they gather all the information, they use open-ended questions, so we don't say, do you live at such and such an address, we say, where do you live? The information is then verified by independent sources, again, using open-ended questions. We check their criminal history, and what we're primarily looking for is their risk, or their failure to appear in the past. We attend all courts in Rochester City Court and all county Supreme Courts. Like I said earlier, for town courts, we have to actually see a defendant after they're held in custody, and then post-arraignment, we send out recommendations to the judges regarding their release. The risk assessment is really geared towards putting defendants in categories of low risk, medium risk, and high risk, again, with regard to whether they're going to appear in court. Once we have different levels of release options available to the court. Just to back up, for those who may be wondering, when our staff go in there, most of them are trained in motivational interviewing. We're trying to train most of the staff and being obviously sensitive to not only the defendant's situation, but obviously victims. So for certain charges, or actually most charges, the staff have to make sure that they're finding an alternate address. They have to make sure that we are further not victimizing people. We try to avoid calling the victim. If you imagine the defendant was arrested last night for assaulting their wife or other person or significant other, they go into custody. We don't want to call that individual in the morning and say, hi, the defendant may be released today, how are you? We want to verify where they live and everything. We try to speak with other members of their family and find alternate addresses for the defendant to stay at, or they may not be recommended. So if the defendant isn't on domestic violence or some other charge like that, assault, anything, we will not make a recommendation unless we have somewhere that we can verify that's a safe alternative address for them to stay at. Once a person is released, we have different levels of release. The basic and most simple level, and for low-risk defendants, is that they are required to call once a week. They also receive notifications from our staff. Our staff will follow up with them if they do happen to violate any order of condition, including failing to appear. Again, defendants are required to make phone calls, and they're required to come back to court once a week. If a defendant fails to make court, our staff will immediately get a hold of them and make sure that they understand the importance of returning to court. For a lot of police officers, I'll tell you one of the most dangerous things that they can do is to go out and effect an arrest off of a warrant. So we want to try to make sure that we are avoiding that situation. Now, I thought the DAs would get into a little bit more, but regard to the bail reform, we could probably speak about that for 4 hours, but they're estimating that about 80 to 85% of the people that are currently in custody in New York State, so across the entire state, will be released. They have to be released by January 1st. Here in Monroe County, looking at our own jail, it's about 200 people. The law pretty much says that courts and judges have to release people ROR, or if not, they have to put reasons on the record for why they're using the least restrictive, non-monetary condition of release. So for this jurisdiction, this county, that pretty much means contact with our agency would be next, or intensive supervision program, like I'll talk about in a few minutes, that we run, would be after that. Defendants also can be, obviously, bail can still be set. But the point of the law, I think, was to try to address indigent and minority defendants who are being held across the country and held here in our own jail, which the United States holds more people than any country across the whole world. And we certainly still want to make sure that we're ensuring public safety. So I'll talk about that in a moment. So the law, that's a very small piece, but the law is super complicated with regard to who can be in, out. Most defendants on misdemeanors, nonviolent felonies, and violations are supposed to receive appearance tickets and be R1 starting January 1st. And like I said, the 200 people in custody right now are going to start being, have bail hearings and being released within the next month. In 1995, we started, what was it? Oh, this is 2011, sorry. We started in 1995, a release under supervision program. It was changed a little bit in 2011. This is for defendants who are medium and medium to high risk off of our risk assessment. They're assigned to a specific case manager. They are required to report in person to that case manager through increased monitoring and defendants release through telephone and office visits. Also, we will do a secondary assessment. That's not an assessment of their flight of risk. It is an assessment of the criminogenic factors and behaviors that they have. And that then is tied to whether or not they receive referrals for certain treatment within the community. So that could be drugs, alcohol, mental health, family counseling, domestic violence, could be anger management. Over the last few years, because of a lack of resources, our agency has actually taken on, without funding, having some in-house groups and classes. So within our agency, we do have anger management. We do have some groups of critical thinking, drug and alcohol education. For full treatment, though, for mental health and drug alcohol, we do refer out to licensed treatment facilities. So that's been good because probation department, so to speak in a moment, also has access to those programs. So a lot of times when you have a defendant who's in crisis or in need right away, we do have groups that they can start right on site, right within our agency. The good thing about release under supervision is obviously when we talk about, you guys are talking about accountability today, there's a certain level of accountability. And if you think about a defendant being released on bail, they just post bail, or they're being ROR'd, or out on their own, or released on their own recognizance, there's really nobody doing any kind of monitoring. So sometimes I say, if you want your neighbor who was arrested for whatever, burglary or anything, to just be out on their own, and really they just have to go after court. And you might know, being their neighbor, they're drinking, they have other issues going on, perhaps they're having some domestic violence issues, or an agency like ours can hold defendants at least somewhat accountable in the sense that they have to check in with us. We're going to do that criminal behavior assessment. We're going to refer them for any services they need. We're going to report to the court if they're violating any conditions of their release. We're also going to report to the court and know pretty quickly if somebody's rearrested and any new charges. So that's important. It's hard for us to monitor orders of protection. The way we can deal with orders of protection is to talk to the defendant, make sure they understand what it means, make sure they understand that they're not to have either any contact or any offensive contact with a victim, and then make sure that they don't violate that to the best of our ability. Sometimes victims or family will call us and let us know that someone has had contact with them, someone was in their house they weren't supposed to be, and that there's an order of protection. If we're monitoring a defendant, we know there's an order of protection. Number one, we can talk to the victim or the victim's family or even the defense family and point them to the DA's office or the victim assistance programs that have spoken today or will speak today. And also we can make sure that the victim knows who to call and where to call to go get help, whether that's calling 911, whether that's calling the victim assistance, the DA's office to report what's going on. We report any non-compliance under this intensive supervision program pretty much right away. So the defendant's not keeping in touch with us, they're not following through with an order, maybe the judge orders drug testing or something like that, or we do find out there's a new arrest, we can let the court know right away. It's really up to the judges, number one, to go backwards, to decide if they want to release someone. It's not up to us, so it's just a recommendation on the risk. And number two, it's up to the courts to decide how they want to respond to any kind of non-compliance. We do have electronic monitoring available. It's a shared program with probation. Some defendants are released that are high risk who go on to electronic monitoring. It is passive electronic monitoring, so we get reports the next morning. I know does not help ensure public safety 100%. It's not full GPS, but at least it gives us an idea of being able to again, hold the defendant accountable to their schedule, where they're supposed to be, where they're not supposed to be, and then report to the court whether or not they are behaving well on electronic monitoring. This is always in conjunction with our RUS program and the case manager. Electronic monitoring as of January will be severely limited in its use. So the bail reform has, again, I said most misdemeanors and nonviolent felonies and violations have the presumption of release, the release to an appearance ticket, and they're to be ROR'd. There's only a few charges and situations where a defendant can put a defendant on, or a judge can put a defendant on electronic monitoring starting in January. So we may have about 100, 120 people on electronic monitoring a year from the pretrial side. Probation has more. As of January 1st, that number will probably go down because the judges are severely limited. It also limits the amount of time they can be on electronic monitoring to 60 days. So now I could have somebody on electronic monitoring for up to 6 months or more while the case is pending. But now defendants will not be able to have the ability to be on electronic monitoring like they are now. Separate from release from custody programs or diversion programs, again, these are defendants who are already ROR and they're out of custody. Through the DA's office, Bill Gargan and those guys, we have a felony DWI diversion program and a traditional diversion program. Basically, diversion programs offer the opportunity to enter and complete treatment in lieu of prosecution. Defendants are assessed and appropriate treatment resources selected by the counselor and referral and monitoring of their progress. So what'll happen when the case is pending, the judge and the attorneys will get together and they will talk about the case, whether or not they have a certain amount of evidence and how much weight of the evidence they have. And they may decide that they're gonna make an offer to the defendant that if they go through our diversion program, those charges may be either reduced or dismissed. They will then be referred over to our office by the court. It is a voluntary program, so if the defendant does not want to participate in that program, they are reported back to the court that they're not gonna participate, and then the DA's office would go forward with prosecution. If they do decide to participate in our program, this is one of those moments where the clock stops for speedy trial that we talked about, and the defendant will enter into our program. They'll be assigned a case manager. Again, the case manager will do a full assessment on what their needs are. Not necessarily we're looking at whether or not the person's guilty at this point, because obviously everything that we do is pre-trial. No one's been convicted yet. That's another thing that we need to keep in mind. But we're trying to look at what was the circumstances for why that defendant got arrested that day. We get some domestic violence charges. I would say we don't get a ton in the diversion program, but we take any misdemeanors and non-violent charges that are referred to us. The defendant then will be sent out for treatment, or some of the in-house groups we have, to address the needs that we're presenting with them. And the diversion program really is about avoiding future rearrest. So unlike our other programs I spoke about, which were based on the law, which is do they come back to court, do they make their court dates, the diversion program, really to be successful, we're gonna see if you followed through the recommendations that we made for you, and also we're gonna have some discussions with you, and so there's gonna be some counseling as to whether or not you've at least accepted some amount of responsibility for the behaviors that had you arrested that night. So our traditional, or what we call now our promise program, is primarily misdemeanors and low-level felonies. Again, it's voluntary. There's a performance contract that must be signed by the defendant stating they're gonna accomplish certain tasks. They must have an attorney. If successful, the DA's office often, as I said, dismisses or reduces the charges. If unsuccessful, the case will go back for full prosecution. We have a felony DWI diversion program that we started many years ago in conjunction with the DA's office. So when they have someone arrested for DWI, they look at whether there was an accident, whether their situation is with the victim, whether there was an injury, property damage, what the level of the defendant's intoxication was at the time of their arrest. And they will screen certain of those cases and refer them at the felony level over to our office. Those defendants who voluntarily participate in this program must waive their speedy trial rights. And then if they're successful, the felony goes to a misdemeanor. Okay, so it's a chance to take the defendant's felony charge to a misdemeanor. As you can imagine, it's usually not multiple offenders. It's not usually people with multiple felonies. It's usually first-time offenders. If they're unsuccessful, they get prosecuted on the felony charge. We are one of the few programs in the country that actually do this, let alone we require them to talk about accountability, turn in their license. And if they do not, then we don't accept them in the program. So they have to turn in their license. We have to have proof they turn in the license. They are not to drive. If our staff see them driving or catch them driving or they get a new arrest for driving, they will be kicked out of our program. A lot of diversion programs don't do that. That's one of the caveats we've had with regard to our felony DWI diversion program for holding people accountable. We're pre-trial, but one of the only things we do is a sentence program. So oftentimes when defendants get arrested and they get convicted for AUO, or which is aggravated unlicensed operation of a motor vehicle, or DWI charges here in the county, and they may or may not serve jail time. Sometimes you see those defendants out cleaning the highway. Everybody's seen them out cleaning the highway. Or they're in custody over the weekend. We offered an alternative program, which is they don't stay overnight, but they come Friday night, Saturday, and Sunday. It's an alternative to jail weekends. One accountability factor, if you will, is that our program does not count as nights in jail. So when somebody goes into custody, they get credit for how long they're in custody, so it may shorten their sentence. This program does not allow them to do that. A lot of defendants would prefer to clean the highway, believe it or not, or they would prefer to sit in jail so they can watch football on Sundays, versus come to our program, because our program has specific program with regard to DWI-related activities, behavior, how it impacts your family, your children, your finances, how it impacts your health and everything else. They are drug tested and alka-censored during the weekend, and I would say the average weekends are 8 for defendants to be sentenced, so about 8 weekends for a defendant in that first time TWI. Typically, again, we don't see a lot of people that have multiple long histories. It's more geared towards defendants who are in their first few charges. So what do we provide? We provide verified information. So an example of that with regard to sometimes victim rights is you have a defendant who goes in for arraignment, maybe it's on a domestic violence charge, assault charge, some other charge like that, involving a victim, and the judge may say, I'm willing to release you, where do you live? And oftentimes the defendant will say, I live on 52 Main Street, and I go back there and I live with my husband or spouse or wife or whoever. A lot of times our staff can be, no, we know where they live, we're verifying where they live, we verify where they can go back to. We assist in making informed bail decisions. Judges should have all the information available to them to make the best decision they can, especially starting here in January. We help ensure public safety, I said, by holding the defendant accountable to judges' orders and what responsibilities they have to us while they're on program, also addressing the issues that they have. We can increase the appearance rate, so making sure more defendants return to court. That's going to be a big issue in January. The county is definitely, the state is worried that warrants are going to just rise if defendants are not coming back and somebody's not holding them accountable. We can reduce pretrial misconduct and make sure defendants are not being rearrested and or making sure that the rep court know when they're rearrested. Certainly saves the county taxpayers dollars and money for having defendants out of custody versus in custody, and then making sure that they are being maintained safely in the community. So I'm getting the done signal. Be happy to answer some questions. There's blue pamphlets up here. I don't think I have enough for everybody, but there are pamphlets up here for those that would like to see more information about our agency, our main numbers, and they can get a hold of me to ask me any other questions that you have.
Which one moves it, the arrow?
Well, forward moves it forward.
One on the right.
One on the right?
Yeah.
Moves it forward, okay. Moving along, folks, I'm Jack Brennick from the Batterer Accountability conversation today. Bill was talking about 30 years ago. That was when I first went to a Duluth training to learn about offender accountability. And I wanted nothing to do with it. I was a school counselor at a high school far away from here. And I was approached by the women's shelter, and I didn't know nothing about, this is '89, I didn't know nothing about shelters or any of that. But what had happened was the shelter had been set on fire. I knew a building got set on fire, but I didn't know what it was. Anyway, they approached me and they had this idea about an offender accountability program that was getting supported by a judge in that community. And they were explaining what they were talking about. Like, well, these are men that are engaging in physical violence, verbal and emotional abuse. I wasn't even sure I knew what that was. Financial abuse. They are engaging in restricting access to resources. And I'm like, do I? And they had come to me because I was the counselor at the high school. I was pretty good at talking with boys. Boys who were fighting in classrooms, talking back to teachers and on their way to the principal or on their way to the superintendent. And I probably made one of the most naive comments I ever made to anybody. These two women who were asking me to go to this Duluth training. I said, I'm good with boys. I don't know what boys have to do with men. And you know, I didn't have any sons, and I was like, I could see their eyes rolling. And then work in progress. So 30 years later, here I am still, you know, pondering domestic violence and offender accountability. Lately, the model for addressing across the country has been this 26-week class designed to promote accountability, to promote community education, and promote survivor safety, not in any particular order. But one of the things that has come up is just sort of this constructs around masculinity, and this is one of them. This comes from Tony Porter, a guy named Tony Porter and Ted Bunch. These guys are out of New York City. They're called the Call to Men, Call to Men, too, these two guys. And they have started a conversation nationally about some construction in men's identity, not necessarily in America, but probably around the world, where they call it the 3 agreements that men have made about women. Now, I got a bunch of sisters. I remember showing this to them, and they were like, see, now Jack's even talking about it. And that was probably 8 or 9 years ago. So here it is, women, these are problematic agreements that they'll say nobody shook on, but somehow men start, if they're not thinking too much, they start doing this almost unconsciously, that women are property, that women are inferior, and that women are objects. So we've started to build this into our conversations with men, and how it plays out in the way they manage disagreement and conflict with the people, with the women, with their children. My bias is I mostly have conversations with men. This doesn't exempt that women can also prescribe to these things, but it seems to me men are creating more of the problem with regard to the problem of domestic violence. So we challenge these agreements and challenge to see the depth of how these are existent. The property part, frequently the men who come to these domestic violence classes, they won't use the woman's first name. They'll say my wife, my girlfriend. They might say something worse. And so we might say, what's her name? And then, well, her name's Susan. And then they'll later, well, my wife, and I'll go, well, what's her name? And then they're like, how come you keep asking me? And well, I'm more fixated on the my rather than the, needing to know, needing to get in your business. And it's sort of intention. So ownership, because my wife, my car, my kids, my house, my stuff. The inferior part, I don't need to go into a long conversation about equity and, distribution of resources and where it goes. Objectification, this is another one of those. If we can make somebody an object, then they lose their humanity. And so a lot of the men engage in objectification processes, and this somehow gives permission to become more abusive. So I'd just say, a few more minutes, yeah. Oh, go ahead.
Would you say that those 3 tenets are the difference between batterer intervention program and anger management program?
Yeah, Ally was saying, is this connected to maybe anger management and better accountability programs? Yes, in the sense that those 3 agreements, I guess I'll go back to them, they're fixated around belief systems. Anger management typically is more skill-based and may not address underlying belief systems. One man came to me and he says, "Yeah, I got an anger problem." And I go, "You got an anger problem?" And he was kind of angry when he was saying it, so I'm kind of believing him. And he goes, I go, "When do you got this problem?" "Oh, all the time." And I'm like, "Okay, you got it all the time." But I did notice that he works, 40 hours a week at the same job for like 15 years. So I go, "So you got it at work?" And he goes, "Well, no, not at work." And I said, "So all the time, but not at work, so not 40 hours a week." And then I noticed that he went to go visit some elderly, person in his family, once a week. I go, "So what about that anger management problem that you have all the time? Do you ever have it at the nursing home when you go visit?" "No, I'm not gonna have it then." I said, "All right, so you have it all the time except not 40 hours a week and not 3 hours on Sunday when you go visit Aunt Sophie. So when do you really have this anger management problem that you say you have?" And then we eventually backed ourselves into a corner realizing this was about choices and decisions, and it was about when I'm with my partner and she's doing stuff I don't like. So now I got an anger management problem all the time. And so that is a different conversation than, you should learn how to have patience. One guy said he wanted patience so he could learn to put up with their BS. So I'm less concerned about the patience, a little more concerned about the conceptualization, the belief system about what's BS. And a lot of times this is under the abusive mentality, all these things, needing to be right, superiority, privilege. If you want to get clinical, we're starting to talk about narcissism, and I decide what is important in this conversation. So if I'm having a conversation with anybody, if I'm deciding what you're saying is not important, I just might call it BS and start getting frustrated when you keep bringing it up. So the anger management piece probably has its place. I like to believe that, if I'm going to be having conversations about domestic violence accountability, if we get close enough to belief systems, anger is rooted in belief systems. I mean, that's a theory. So that's kind of how I think about that. Who are they? I've been talking about, the characteristics, and, I guess one of the glaring characteristics is minimization, denial, and blame. When you start hearing only, just, and but, these are the terms. The police were only there 15 minutes, it was just one time, I don't know, it goes on and on and on. So we challenge that. That's what, and the opposite, if you want to get very technical about minimization, denial, and blame, the opposite is accountability. Oh my God, I never realized that. So sometimes that's a long road to get to that, because if I'm really rooted in my rationalizations and my denial and my minimizing, who are you to challenge me on that? What's the motivation to change? This is a good checklist. It comes out of, have you heard of it? This is a smart guy, Lundy Bancroft. He wrote a book called Why Does He Do That? And over at the Resolve Agency, we got some of the Resolve staff here. I saw like 25 copies of it. Or you must give it away, or I don't know. Okay. Go to Amy and Kate back there, and they got copies of this. But in the back of the book, there's a checklist. How to, because some of the men who come to the class, they want to know, they might have a sense they're changing, but they want to know, when is she going to notice it? And that checklist doesn't include, did you bring flowers on Valentine's Day, or, how big was, Christmas? This has to do with full-on, raw accountability. And it's a pretty good checklist. So I show that to, there it is. Why does he do that? So I show that to the participants. And so we've got one of the programs at Delphi, and we've got some therapists around town that are doing it. Oh, one last question for Joanne, a recovering facilitator from the DV program.
My question is for everyone who works with survivors. What's good for them to know about the program, as far as what the men might say to the survivor about the program, or safety issues, anything like that?
Yeah, Joanne's asking, what's a good thing that for survivors might need to know or want to know if, say, their partner comes to the class. Okay, this is not a cure, this program. All right, that's number one. I think what survivors also going to know is sometimes the men are going to present a carefully crafted version. I got accused of taking a public opinion survey in the class, and Mrs. So-and-so called. And she says, my husband said that you did a survey and that everybody said I'm wrong. And I go, did he ever lie to you? She goes, he lies all the time. And I'm like, yeah, we don't do surveys. And she's like, ooh. So, yeah, it's not a promise of returning to the relationship. I tell the men all the time. So, anyway, lack of accountability. So, we don't believe everything they say also. What if he tells you that I'm the one who started the fight? you know. Okay, next, probation. Thank you very much, folks. Get Pete up there.
Good morning. My name is Julie Wagner. I'm the supervisor for the Domestic Violence Intensive Supervision Program at Probation here in Monroe County. I'm just going to give you a little bit of background about our DVIS program and just throw out some numbers that you might be interested in. Our senior DV officer is here and is going to talk a little bit more specifically about DV supervision. The Domestic Violence Intensive Supervision Program consists of a specialized team of probation officers which focuses both on the investigation and intensive supervision of DV offenders, emphasizing both victim safety and holding DV offenders accountable for their abusive behaviors. We're part of the Adult Criminal Supervision Division, and right now our team consists of one DV investigator who completes DV-related pre-sentence investigations. What we try to do in these PSIs is really develop and show the pattern of behavior, the history. There's enhanced victim contact to the point of however the victim wants to be engaged or involved with the process. Our DV investigator has a lot of contacts with victim advocates working through the program. So we have a lot of information, history in these investigations that then go back to court and are part of the sentencing process. In addition to our DV investigator, we have one senior probation officer, Pete Schmidt, who will be talking to you in a little bit, and two intensive DV supervision officers. They carry a specialized caseload. It's a reduced caseload of about 50 to 60 individuals who have been convicted for DV offenses. They have specific conditions of probation, including mandate for the offender accountability programs. I'd say the majority of our DV offenders are mandated by the courts to complete these programs. In addition, they can also be sentenced to the Domestic Violence Electronic Monitoring Program, which sets up exclusion zones for the victim. So if the victim's home, work, school, those are all areas that the DV offender is not allowed to go into. I'll probably let you explain a little bit more detail about that, but basically it's a tool. It's not something that's going to automatically call police if there's a violation of that zone, but it's something where we can really reach out, contact if there are any violations and report. Just some numbers right now at probation. Since the first of this year, we've had 101 new cases that have been opened as a domestic violence case. Not all of them are supervised by our intensive unit. However, I'd say majority of them are right now. We have 293 active adult supervision cases that are identified as DV, and 173 are supervised by our DVISP team. And currently on probation as whole, we have 293. Right now, our PSI DV-related offenders coming through are averaging about 14 per month. And I guess I'm going to have you come up, maybe talk a little bit more about the supervision process. And
I just have a question.
Sure.
How are the numbers? Are they increasing, decreasing?
They increased a little bit from last year. And I've just started really tracking. We just started with our DV investigators, so I just started tracking that this year. I know when I did it many years ago, I was averaging probably about 8 to 9 cases a month, and now we're up to 14, 15. So I am seeing that increase, but I don't have a long-term history of that.
Thank you.
Mm-hmm.
Hi, I'm Pete Schmidt. I supervise caseload of domestic violence offenders. I've been crunched for time here, so I'll be very brief. Just to keep in mind, probation is a sanction in lieu of incarceration, so The judge will give you conditions to follow. If the people don't follow that, then there's the threat of going to jail. So just because they're not currently incarcerated doesn't mean that it won't happen if they don't follow what they're supposed to do. So, like Julie said, initially before we get the case, someone has reached out to the victim and spoken with them. If we have contact information for them, if they choose to participate, we'll have their contact information. So upon receiving a supervision case, I'll also reach out to get in contact with them to see if they want to have regular contact with me, providing my name and number and that kind of thing. So basically, the basic conditions of probation for a domestic violence offender are not get arrested, obviously, report to the office once a week, we do visits to their houses, matter accountability program, drug and alcohol evaluations and treatment, mental health evaluations and treatment. Sometimes they'll throw in the anger management also. Also the orders of protection, you have to comply with all orders of protection. So we try to enforce that to the law. So if we get word of that, we send them cases back to court if we can. So a lot of our clients do get arrested. So when that does happen, if there's noncompliance, we try to be swift with a new arrest, especially if they're involving the same victim and domestic violence related. We usually request a warrant for the judge to sign to get the person in custody. And I guess with the new bail reform, I'm not sure what's going to happen with all that, but soon we'll be trying to do more warrants if possible to keep people in custody. So what else we got here? So one more. So it doesn't always rise to the to a violation probation event. So sometimes we'll use graduated sanctions. If somebody fails a drug test, you don't send them back to court necessarily right away. You just increase their reporting. Do more drug testing. Supervisor will yell at them sometimes. Modify their conditions if possible to include sometimes a domestic violence electronic monitoring program, which you talked about. Basically what that is the offender's outfitted with a GPS device, and we can give them a schedule if they have to be at home at certain times, and they're monitored 24/7. And if we can set up zones around the victim's house, their employment, or anywhere else, church that they would frequent, to keep them out of that zone. And if the GPS gets, if they go into that zone, and we could have a police response, probation response, or depending on if the person's still, maybe just call them and make sure they get the hell out of there. And so usually when somebody does that kind of violation, we do try to get the court involved with that as well, because going back to that program, we can also set it up so the victim will get text to their cell phone if the person does enter the zone, so they'll have a little more time to follow their safety plan and follow through with that. So
I think one of the things we also have to look at is victim safety is primary. There are occasions when we will have information that there's continued abusive behavior, and if we revealed that in a court notification or a violation of probation, that would impact the victim and put them in very unsafe conditions. So we have to sometimes weigh that with our, how we address the problem with ongoing sanctions. It might be we know something is going on, but we can't file that violation. The victim doesn't want that information out there. So maybe we bring that person in for more reports. Maybe we bring them in for more screenings. Looking for alternatives, a way to have that accountability factor without giving them knowledge that we've been in contact with the victim.
okay. And let's see. We also, in addition to, we also try to work with them to try to have take care of their other barriers, mental health barriers, employment barriers, educational barriers, drug and alcohol issues. Are we with time? Good. All right. Sometimes, at the end of the day, I think sometimes probationers are going to jail, and it's sometimes that's the only way, due to their conduct, that we can ensure safety, accountability. So we try to focus on the behavior of the client, obviously, They'll come in, they'll try to minimize things, justify things, and, since I'm a male, they'll try to, say, how it is, so we try to check them on that, and that's that, so.
Questions for probation?
Are most of your clients compliant, is the word I'm looking for?
So most would mean 50% or more.
What
Probably,
percentage
yeah.
of your clients are compliant?
I guess there are different levels of
Yeah.
compliance, whether they are compliant with paying their court surcharge, whether they're compliant with attending the Rapid Intervention Program, or compliant with not being rearrested. I mean, we have some people who we're getting reports on every day, and they're just not compliant at all. We have others who are generally compliant, they're keeping most of the reports to probation, they're home when we schedule home visits. But maybe they haven't done one or two of the conditions. So it's always a working process and having to balance, what we feel is the risk and how we address that. Is it something we need to notify the court about, or is that something that we can continue working with that person? And as Pete said, do I come down and have a conversation with them, do we have them report maybe more than the one time a week, bring them in twice a week, or do an extra home visit, things like that. So those are some of our options.
I think right now I have 52 cases, and I think about 16 violations of probation pending, so, but that doesn't mean they're always doing anyways. You don't follow them around 24/7, so, anyways, so, thank you.
Thank you.
Good morning, good afternoon, time is flying quickly, so I'm going to try to be really brief and really quick. I have a lot to editorialize on all this work, but I'll condense it very quickly. My role here, I'm Pete Navardshill, and I'm from Tree of Hope. I also consult with Resolve. I'm also on the DVC Education Committee. I've been doing the work in the community since the mid-1990s. I want to focus just briefly, it's like a switching of gears. We've been focusing a lot on criminal court, and now move to the family court, and we're out of time. So I'm going to do this very briefly. In your handouts, there are 3 guides. There's a guide, it's one is a family court judicial guide to domestic violence risk factors. There's another one on matrimonial. And there's a third one that came out of Lifespan. I'm not sure if anybody's here from Lifespan. Okay, so you can address at the end. I assisted actually Tracy Siebert, who's the architect of these guides. And very briefly, the reason I want to point out these guides to you is that these guides were developed by the Unified Court System in conjunction with the Center for Court Innovation as guides to give to the jurist on the bench, the judge, some criteria and a tool to use just to go through the risk factors that judges in family court. And I know that Legal Aid, and I know Kristen and Hannah are going to talk a little bit more about that process. There are 3 different levels of family court activity, and each of those particular specific courts may have a little bit of a different bend on the issues and how they apply. So for example, there is a domestic violence intensive intervention court in Rochester where someone can go for an ex parte temporary order of protection. The big difference is that the jurist is not looking necessarily at crime, like in a criminal case, but they're really looking more at the dynamics of what's going on in the case to see if these risk factors are present. And the primary objective is not justice, it's safety. And what they're looking at, and you will see if you look at these cards, you will see mention of lethality risk. What they're looking for is an order of protection and whether or not there's jurisdiction and whether there are risk factors here that lead to lethality. In other words, to say that is homicide prevention. So the objective is if there are factors present here that meet the legal criteria, that put someone at risk for a lethality risk, then that becomes the purpose for issuing an order of protection. The other things that can be addressed in family court are things like custody and visitation issues, things like child support, and most importantly, addressing safety, safety, safety. So the importance of these cards, just as a backdrop, it does provide the complex nature of risk factors that judges can use. The IDV court, the Integrated Domestic Violence Court, very quickly, is an interesting court. It was designed in the early 2000s, and it was designed for cases that had a combination of criminal charges and also family offenses. And it was designed that one judge could specifically take a case and deal with the criminal, the family, and the matrimonial issues all in one court. I don't know if it's actually implemented that way today, but that's what's called the Integrated Domestic Violence Court. And most of the time, there is an order of protection that is violated, that becomes a criminal offense. And the criminal offense, along with the family offense, makes it eligible to go into the IDV court, and that is a Supreme Court, which means that it has the jurisdiction to deal with both criminal and family offenses. So the cards that I have, that you have in your packet, at least give you an idea of what the judges are looking at in family offenses as they're putting together the criteria and the relief that can go into an order of protection. So that's just the backdrop for that.
Is it okay to share these with clients?
Yes, it is. These are public domain documents. They were produced by the Center for Court Innovation, which is a state not-for-profit. So they are free to distribute. But they just represent the complexity of issues. Really, I look at this and I think if I'm a jurist on the bench, and I know in IDV or in the Domestic Violence Intensive Intervention Court, they get up to 30 walk-ins a day on top of a docket. That you're looking at all these criteria and you're going case to case to case. This is a really complicated process. It's a lot of hard work. All right. Any other questions? Move on. All right. I'll let Hannah and Kristen.
So while she's pulling up the PowerPoint, my name is Hannah Sonner, and I obviously work for Willow Domestic Violence Center, and I'm the coordinator of our court advocacy program. So as Pete was explaining a little bit more about the domestic violence court that we have in the Hall of Justice, myself and some other advocates that are also here work there every day so that while people are coming in and file for these orders of protection in family court, we're there as a support for them through that process, help answer questions, and also providing some really key services like safety planning and connecting with other Willow services as well.
And I am Kristen Pecora. I am the director of the Family Law Unit at the Legal Aid Society of Rochester. And we do have multiple collaborations with Willow, and our focus at Legal Aid is prioritizing victims of domestic violence.
So, clicker. Okay. So obviously the objectives that Chris and I are here to talk about today is we want to understand a little bit further about how the process of someone filing for an order in family court happens, and then also looking to see how we can use these orders of protection in family court as an accountability tool. And then we also have some tools that you guys will have in your packet that you can take with you, because I know this process can be really overwhelming at first. So we have a couple different tools in your packet to help break it down for you even after you leave here today. So one of them is distinguishing between family court and criminal court. Sometimes clients may say, you know, I don't want to call the police, or should I call the police, or should they told me to go to family court, I don't know if I want to press charges or if I want to pursue through family court, can I do both? So this really helps break that down so a survivor can make an educated decision about what they want to do. The other one is we've also broken down the process of if they choose to file for an order of protection in family court, you can actually see step by step what they will actually go through. So family court orders of protection, they are civil orders. So like Pete mentioned, we spent the majority of the morning talking about the criminal process. This is a civil court, so they do not have to press charges to pursue a family court order of protection. Also, by them pursuing the order of protection in family court, that is not the survivor pressing charges. Now, if there is an order of protection in place, like they do file for this family court order of protection, it's in place and the respondent or the abuser violates the order, then it could result in a criminal charge, but just the order in itself will not result in a criminal charge for the abuser. As Pete had mentioned, those cards he was talking about, even though it's a civil process, it's still a legal process. So even though someone is going in to file for an order of protection, there is no guarantees that they will be granted an order of protection. It's up to a judge, and there are certain legal requirements that they have to meet, and those are called family offenses. So there's also a document that a survivor will write with a probation assistant called a petition. And clarity and details in a petition is extremely important because that's what they're sending to the judge to say, hey, this is why I feel unsafe, this is why I need an order of protection. Yes, they can elaborate a little bit more on it when they're in the courtroom, but if it's not in that written document, it weakens their case. And then participation by the petitioner is required. So as Ann was talking about earlier, with the DA's office, if a survivor says, no, I don't want to pursue charges or I don't want to be active in this case, the DA can then say, well, I don't care, I'm just going to move forward and do it. In family court, if a petitioner doesn't show up or chooses not to engage in that process, then the process stops. So the petitioner has, and the survivor has significant more control over this process than they do in the criminal sphere. There is a lower burden of proof, so because it's a civil court, like when they go in to file for orders of protection, people often, they will bring their evidence with them. They'll bring photos, they'll bring their police reports, they'll bring their own journals that they've written, and that's great, and it's really helpful when you're writing a petition, but a judge actually doesn't need to see any of that, and they probably won't need to see any of that. Like Pete said, we could have upwards of 50 cases a day. Those are coming back to court and new filers, so we honestly just don't have the time, and there's also not the necessity in the law. So the judge is just taking you basically at your word and saying, I believe what you're telling me, I just need to find enough to grant an order of protection. We can talk about proof later. The records are private, so no one can walk in and say, hey, can I see file for orders of protection today? But the courtrooms are public. That's not really, I don't think, very public knowledge. So there isn't an audience sitting in our courtroom. Our courtroom is actually pretty small. It's nothing like you see on Judge Judy. I tell my clients that all the time. It's not like traffic court where you're going in and there's 15 other people there who are waiting for their cases to be called. Pretty much anyone in the courtroom is affiliated with the court. So sometimes there are attorneys that are sitting in the back there, there are clerks and everything like that, but they hear that all day, so they're tuning you out. So it is a much more private courtroom. And like I said, the petitioner, the survivor, does have control over the order of protection, so they can request specific provisions, they can modify their order at any time, and they can withdraw their order at any time. You could file for an order at 9 a.m., get an order by 10, you could come back in at 3 p.m. and say, I want to withdraw, and that's okay. And the survivor has the choice to violate their order of protection in family court or in criminal court. Again, if you choose to violate the order of protection in family court, so someone violated the order, you want it documented, you go to family court, that's not a criminal charge. It is eligible for a criminal charge, so if you wanted to file a criminal charge, it would just need to be done through the police, and then you're going to start engaging in the criminal process. So there could be two processes happening. You could have a criminal charge pending, you could have this family court order of protection, and like Pete mentioned earlier, that is an instance where they may be pulled up into a different court called the Integrated Domestic Violence Court, where one judge is going to oversee all these things rather than going to a criminal court and then a family court. There are two different types of orders of protection. I call these bare bones orders of protection because every order can be modified to specific needs. So the basic one is a lower level of protection. We call a refrain or no offensive contact order. So that basically says you can still be together, be around each other, talk to each other as much as you want, live together. It basically says that if things start to escalate, that you have the right to call the police, document that, you could come in and file a violation. That would be technically against this order. Refrains are hard to violate and they're hard to prove violations. So that's just something to know, that if a survivor is coming in and saying, yeah, I think I want to go forward with a refrain order of protection, okay, let's talk about what that would look like in your day-to-day life. So if it may say that the abuser can't call you names, certainly can't put their hands on you, but those things can be hard to prove, especially when police are just responding to the scene, so that's just something to keep in mind. A stay-away order of protection, or no contact order, is the traditional order of protection that we normally think of. So this order of protection would say that they would have to stay 500 feet away from you, they can be removed from the house, and they're to have no contact with you. So that no contact piece is also no contact whatsoever, not just offensive contact. So they can't send you a text saying how sorry they are. They can't ask you about how your mom is doing. That's no contact whatsoever.
They also can't have third parties contact you as well.
Yeah.
So they can't have their brother text you and say, hey, so-and-so wants to know how you're doing. That would be a violation.
And then, like I said, you can also ask for some other specifics in your order of protection. So you can have them removed from the home, no matter who owns the home, no matter who's on the lease. We have a lot of survivors come in and say, you know, their name is on the lease or their name is on the deed to the house. I've never paid any bills, but I've been living there for 20 years with them. That's okay. If your safety is at risk, a judge can remove that person from a home. Now, whether or not that'll last long term, an attorney can talk to you more about that, but on a temporary basis, for your safety, that person can be removed from the home. Children can be protected under orders of protection. You can also have some custody or visitation stipulations in there. So you can be awarded temporary custody of your children on a temporary basis if it's warranted, determined by the judge. You can have certain items of yours returned upon service of the order. So when that person gets the order of protection, if they have your keys or your cell phone, they're ordered by the judge to return those back to you, and that's usually done through the police. So the police will be the go-between for that. Pets can also be protected under an order of protection. We see often that abusers have harmed or have threatened to harm pets in the home, and so you can't ask for your dog or your cat or your fish to be included in your order.
And they do it.
They
The
do.
judges take it pretty serious here, so
Yes.
don't be afraid to advocate for that.
You can also ask for temporary child support and the removal of guns as well. So you just have to tell the judge that you have seen a gun, describe it, or you know where they keep it, and then a part of that order will be that the gun be removed. But with every order of protection, there's always a stipulation in there, whether it's a refrain or a stay away, that that person can't have access to weapons moving forward now that there's an order of protection in place. You could also ask for a mental health and a substance abuse evaluation for the respondent, the offender, the abuser. Questions so far? I'm going fast to stay up with time.
The temporary custody that you can ask for, is that only with a no contact or stay away, or is it with a refrain?
So she was asking if you could have temporary custody only with the stay away order, or if you could have one with a refrain. You can have temporary custody with the refrain. Other questions so far? Okay. So there can also be exceptions. So we know that life is messy, and we know that these people may share children together, and they may have to still have some contact. And what that looks like is going to be determined by the petitioner. So a petitioner can ask, yeah, I don't want to have communication with my current or ex-partner, but we have children together, and we'd really like to go to the soccer games together. I don't want to keep, my child's father or my child's mother away from my kids' soccer games. So maybe they'll say, you have to stay 500 feet away from this person, except at school events for the child or sporting events for the child. And sometimes the judge will get even specific enough to say, at those events, you have to stay 15 feet away from that person. We see that as well when people may be working at the same place. You have to stay away from that person, have no contact with them except when you're in the workplace, and even then, still no offensive contact, so you still can't be abusive towards them, but the minimal contact that you have to have for work is okay. Same with children, stay away from the home except when visitation exchanges have to occur. That's often through a curbside visit. So they'll say, you can't come into the home, you can't acknowledge me at all whatsoever, you can't say hi to me, you can't talk to me, but you'll pull up to the curb, kids will get out of the car, they'll walk to the door, and then you'll drive away. And then they can also ask for a stay away from the home only. So we see this a lot with maybe older adults who are coming in to file against their children. And they say, you know, my daughter has a drug addiction and I'd really love to be there for her, I wanna support her, but I just can't have her living with me anymore. So they'll say, okay, we'll have your daughter stay away from your home, communication is fine, you guys can meet up at Dunkin' Donuts, whatever, and talk about what's been going on so you guys can still have contact, just not at your home. And so the list of exceptions can go on and on. And sometimes our judges get really creative when we hear something that we've never heard before, and our judges can get pretty creative. So again, in this flow chart, this is basically what I'm going to run through. So things to know about filing for a family court order of protection. The first thing to know is that there has to be a certain relationship. So obviously we're talking about domestic violence. So if they're in an intimate relationship, whether it's current or whether it's a past relationship, that relationship could have been over for 30 years. But if there was an intimate relationship at some point in time, you can file an order of protection against that person.
And people get caught up on the intimate part. It doesn't have to be a sexual intimate relationship. It can be that the person is just familiar with the person in a more than just a casual, hi, bye, I know you, your neighbor type way. So there's some confusion sometimes there.
And then also someone who's related to you by blood or by marriage. So you can file against your sister-in-law, you can file against your cousin. The other important thing to know about filing for orders of protection is that it's a really long process. And you have to be 18 years older, 18 years of age or older to file for an order. If you're a teen in a teen dating violence relationship, a parental figure would have to file on your behalf. So your mom or your dad could come in, file on your behalf against the other party. But getting back to that, it takes a really long time. We suggest to plan for maybe 3 to 4 hours at the minimum. And so the process that someone would go through is first they're going to show up. So they would come to the Hall of Justice, and so that's literally a couple blocks down that way. 99 Exchange Boulevard, right across the street from the Blue Cross Arena. And so they will have to go through some security, prep for like airport security. There is some metal detectors that you'll go through. Once you go through that, you'll take the elevators and you'll go up to the 3rd floor. And so that's the family court floor. It's a really busy floor. So it can be overwhelming when you first get off on that floor, but know that there are deputies on every floor, and if you get lost, you can ask any deputy and say, I want to file for an order of protection, and they'll know exactly where to take you. The window where you're going to start is room 301A. It's labeled as a probation intake window, and there is free childcare available on the family court floor. Children are, for safety reasons, are not allowed in the courtroom itself. So if you do need to bring your child along with you, there is a daycare run by University of Rochester on the third floor, and it's locked, it's secure. So the person who checks the child in and they get matching wristbands is the only one who can pick up the child unless otherwise specified by the adult dropping off the child. So once you go to the probation intake window, you'll fill out an information sheet, basic demographic sheet, who you are and who you're filing against. They'll do some basic screening with you at the window. Mainly they're screening for what kind of relationship it is to make sure that you're qualifying so you're not wasting 4 hours of your day. And then they'll also do some really basic screening about what's been going on because the next step in the process is a probation assistant is going to come, call your name, and they're going to bring you back into their waiting or in their office. In their office, the probation assistant is going to be typing up that petition. Like I mentioned earlier, that's your narrative of the abuse and what you're asking the judge for. So if you are working with a survivor and you want to help prepare them to come to file for an order of protection, help them write their story in a segmented or a bulleted way, starting with most recent incidents. That's the format that the judge likes to see. Trying to remember specific dates, specific incidents, and details, that would be most helpful. Because people get there, it's really overwhelming, it's a long process, so by the time they sit down with the probation assistant and they say, okay, tell me what happened. It's like, there's so much that happened, where do I even start? And then after they write their petition, they can speak with the Willow Advocate if they choose to. So our services are voluntary. Most people want to speak with us, and then some people don't, and that's okay. But we can talk with them about the process. So we are not attorneys, so I can't advise you how your case will turn out. I can't advise you anything legally, but I can tell you what your options are, and I can tell you what to expect, and I can be there through the entire process with you. So I can go in, sit in the courtroom with you. I can answer questions as we get out to the best of my knowledge, and then mainly I'm there for an emotional support. And then once maybe we talk, then cases are moving, case gets called, client goes into the courtroom. If they want an advocate, we'll go in and support them. And then they're gonna talk to the judge about what's in their petition. And a judge might ask some follow-up questions, and then the judge is gonna give you an answer right then and there. So the client will know in the courtroom whether or not they're given an order and what is gonna be in that order of protection. And then if they get the order of protection, they do have to wait for some paperwork. So they'll get their order of protection all written up, so they'll have a copy of it. They're also gonna get something called a service packet. That service packet means that in order for an order of protection to be valid, it needs to be served on the other party. So the other party has to know that it's there. So how that happens is through the police. And so the court will ask the petitioner to call 911. When 911 comes on, they'll say, what's your emergency? I have an order of protection and it needs to be served. Okay, where are you at? The police will show up with you, you'll give them the service packet, and they'll take it from you and they'll go and serve that person. I'm making service sound really easy for sake of time. It's not that easy, it's super complicated. Jurisdictions come into play, so we will have a more in-depth conversation with survivors about service, and service is a really huge hurdle that we see for survivors because you can't move forward in the case until that person has been served with it. And then that's just your first day. And then after your first day, you also get a follow-up court date where you do have to come back to court. If you don't, your case is going to be dismissed, and the other party has the option and the right to show up if they want to. But Willow does have a secure waiting area in the back, so if they would prefer to wait with us, they can wait with us so they don't have to sit right next to their abuser for 4 hours while they're waiting for their case to be called.
Does service have to be performed by the police, or are there other options?
No, so there are other options. Someone over the age of 18 who's not a party in the matter. So if I was a petitioner, I filed against Kristen, I couldn't hand the paperwork to her. But Caitlin, my friend, I could say, hey Caitlin, I have this order of protection. You know Kristen, would you be willing to serve her? Is it safe for you to serve her? And Caitlin would say, yeah, sure, I can do that. Caitlin would just walk up to Kristen's house or see her at work the next day and say, Kristen, I have some paperwork for you. That's it, don't have to explain it. Caitlin would just have to fill out a form given by the court that says, I'm Caitlin, I served Kristen at this day and this time, I knew it was her because XYZ, and then it would be notarized.
So the law is a non-party of suitable age and discretion. Age is 18, and obviously somebody that's of suitable discretion as well.
So when does the petitioner get notified that it's been served?
So usually it's notified by that person, like saying, hey, I served them, or the police will give them a call on their cell phone and say, hey, it's been served. But there's also a free website, it's called sheriffassist.org, and they can go online and they'll type in some numbers at the top of their order, and then they can actually sign up for notifications by text or by email, so they'll actually get written confirmation of your order was served at this day and this time.
And that's when it goes into effect?
Yes, when it's served.
Then sometimes petitioners don't know until they show up to court.
It's not necessary to have Kristen sign that she has received the document.
No,
No.
the respondent doesn't have to sign saying they received it.
The respondent doesn't even have to touch the paperwork, just as long as it's been served. It could be dropped at their feet, and that's suitable service.
These are how to file an order of protection. What do you do to withdraw it?
Same process. You'll come in and you'll go to that same window, but rather than saying, I want to withdraw my order of protection, you'll say, I have one and I want to withdraw it. And then you'll still have to write up a small petition basically saying why you want to withdraw it, which is like a one-page thing. You'll still have to see a judge, but nothing has to be served. So if you go in and you say, I want to withdraw your order, and the judge will say, okay, I've never seen them say no, then that's it. Nothing has to be served. Now that's only for family court orders of protection. If you have a criminal court order of protection, that is a completely separate court. You could not modify, withdraw, do anything to a criminal court order of protection in family court.
And also, if they do have an attorney, the attorney can go in and withdraw for them on their behalf.
In family.
In family.
Including kids in your order of protection, or if you're filing on behalf of a minor, the judge typically wants to interview the child as well, right? So then you don't have to bring them to court with you?
No. Nope. The children should never have to come to court unless there is a trial and one of the attorneys is asked for the child to testify, which is generally not granted. In custody, I think what you're talking about perhaps is an in-camera interview or a Lincoln hearing, and that's, again, only if there is a trial, but the children should never be in court.
Unfortunately, that's been the pattern with So normally, like in their follow-up court dates, they don't have to. Yeah, I know. But when they are filing on behalf of the children, it didn't always used to be this way, but kind of the style of our judges, they've started taking testimony from kids on ex parte appearances.
I've had
Yeah.
clients that have had to leave and come back with their children in
Yeah.
the middle of the process.
Okay, but what on the situation where a mother called a order of protection on her minor daughter's boyfriend?
Yes.
The daughter had to be present then, right?
So she would, again, based off of the pattern of the court, the daughter would only have to be present at the first appearance, so when they're filing for the order of protection, because our judge would want to hear from her. But at follow-up court appearances, she would not have to be there. She'd be assigned an attorney for a child, and that attorney would be her stand-in.
As long as she's under 18?
As long as she's under 18. Now, if it goes to a trial and they need testimony and they need evidence, then they could consider bringing her in for testimony, like Kristen said. Most attorneys for children, that's their absolute last resort.
My question is about survivors that are minors, that are unaccompanied youth, or as many states would say, emancipated.
Yes.
So how do they go about that?
So we actually had a situation this past week where if they're involved with maybe like Villa of Hope, Catholic Family Center, so like an agency could file on their behalf.
Oh, the agency can.
Yes, absolutely.
Yeah.
Whoever would be their guardian or whoever is their custodial.
So if they're like at like a shelter or
Correct.
something like that, okay,
Yeah.
they actually can.
Yes.
Great, thank you.
Yeah. Other questions so far? Okay. Something else important to know is that when the respondent or the abuser is served, they get a copy of the petition. So that's just something to know, so they will have that narrative. Just something I remembered.
Quick question.
Yeah.
Should the petitioner have a copy of the order of protection on them? So like if the police come to the door and they
At
say,
all times.
you know, I don't have.
In their purse, in their car, at
Right.
work, wherever they may be, they should absolutely carry an order with them, a copy of the order.
Yeah, and we make copies for them before they leave if they want them. So if they want 10 copies, we'll give them 10 copies.
The order of protection is valid only for a particular state, or when you move out of state, what happens?
All 50 states, temporary or final. Other questions so far? Okay. So we've already talked about this, has to be served. Petitioner is required to follow up, and then each party has the right to have an attorney. So Willow does referrals to Legal Aid Society for free or low-cost attorneys, and they'll come in and they'll be able to represent them on that next court date. But also something to keep in mind is that just because someone is a petitioner does not automatically make them a survivor. So we also have to keep in mind that abusers are really good at manipulating systems, especially systems of power. And so we know that the court system is one way that they will continue to further abuse the survivor. So maybe the police were called the night before and the abuser overhears the police officer tell the survivor, you should go file for an order of protection. That's when the abuser light bulb goes off and says, well, I'm going to get there first and I'm going to tell my story first. Now, people can have cross orders of protection. It happens actually quite often. But just something to know and keep aware of, that just because someone has a family court order of protection doesn't always necessarily make them the survivor. So at Willow, again, we do court accompaniment, we do all the stuff that Willow does, safety planning, and then connection with shelter and other resources.
Okay, you said y'all referring to legal aid, but I've been in situations a couple times where legal aid's like, well, we can't take any more cases.
Yes. So then we can also do public defender's office for the order of protection cases. If they're willing to hire private attorneys, we can connect them with some resources that we have there. And then also volunteer legal services project could be another free option in Rochester. Other questions before I let Kristen take over? Okay.
Pretty much summed it all up, but I will just go through very quickly and just talk about what the Family Law Unit does. And again, we do get hundreds of applicants and cases through our door weekly But we do definitely prioritize the DV victim cases. Sometimes there's instances where we can't represent a petitioner because perhaps the attorney for the child unit had represented children earlier, so there are conflicts that will sometimes kick cases out and that we can't help. But again, we do try to fit each and every case in as much as we can. If it can fit into a grant, if it can't, we'll try to fit it somewhere. But with regard to what our services are, they include the orders of protection, child support, child custody and visitation, paternity, spousal support, and divorces. We do help, and we're always interested to help those people who are victims and they are encountering roadblocks amongst the service providers. So if you have a victim who is going to court and she or he is saying, I'm trying to get an order of protection, but I'm being turned away, they won't let me file, give us a call. That happens sometimes, okay? So we can advocate on their behalf, service with, issues with service of orders of protection, we can help with that. The victim is not receiving the domestic incident report that's required to be served or given to the victim at the scene of the crime. We can help with that as well. So if there's things beyond just what's listed on this and it relates to family court, domestic violence, give us a call. We'll try to figure something out.
One question. If someone is involved in domestic violence, when they travel across the state, is that record available for other states?
So it should be. There's, I believe, if somebody has an order of protection here or, and they go out of state, they can register that order of protection with the court or with the police department. It is valid, so if there's a violation of an order of protection is a violation regardless of where it is. So even if they get the order here and they're now both in Florida and he violates in Florida, yes, that's going to translate to Florida as well.
How would you register?
How do you register the orders of protection? You can contact the family court.
Okay, you said something about filtering out cases and things like that, but if somebody calls, do y'all listen to the case to decide? Because the people that I have called have just gotten told that they can't take any more cases. And do y'all have a number of cases that don't take a month or something like that? How does that go?
No, it's not that we've met a quota and we're just not taking cases. There's always way too many cases for the amount of attorneys that we have, and sometimes that's what happens. But again, it could be a conflict, but we're not allowed to tell people that there's a conflict. If there's a conflict, we're not gonna say, oh, it's because we represented your kids, or oh, this person can.
Or you representing
We can't disclose what the reason is why we're not taking the case, but generally speaking, we take the cases.
Okay, so when you say there's a conflict, I can't take you, or you don't say that at all?
We don't generally, we don't
You just say
disclose.
you can't take the case? Okay.
Because then people say, well, what's the conflict? Well, we can't talk about the conflict.
Well,
It's
yeah, if they ask
confidentiality,
that.
so.
Okay, so basically, if there's not a conflict, you are listening to everybody?
Oh, yes, every case that comes through our office is looked at, and we try to, like I said, fit it into a grant or give it priority, especially if it's DV.
Okay, so.
We are not turning away victims of domestic violence.
Okay, so.
Just on a whim, like there's. 300% of the poverty income guidelines or lower is what we are allowed to take. So sometimes financials is an issue as well.
Thank you.
Hello, everyone. I got you all at the lunch break. You're all like dying to be done, so I'm gonna try very hard to make this interesting. And also, I'm gonna try really hard not to speak super fast for our awesome interpreters that are up here, but if I am, just tell me to slow down, because I get super excited talking about this stuff. So, my name is Kiki King. I am from the Agency of Society for the Protection and Care of Children, #not Child Protective Services. We are two separate entities. So we are going to be talking today about accountability to children. And some of you might be thinking, this doesn't really apply to me, I don't work with kids. But one thing I want to point out is that if you look around this room, everything we all have in common is that we have all been a child at one point. All of us. So that is a shared experience with people we like and people we work with that maybe we're having a hard time connecting with. So to also then reverse that and think about the fact that, when we're working with kids, we're not working with just kids, we're working with future adults. And when we're working with adults, we're also working with previous children. So there's no time that you really don't have anything to do with kids. All right. So why is it that we actually have to be accountable to kids in the first place? Short answer. When we do not keep children safe, they are more likely to experience lasting negative impacts on their physical and mental health as they become adults. So I think on a base level, most of us knew regarding domestic violence that it wasn't good for kids to be in this situation. All right, so we understood that for the most part, it was having a long-term impact. Now we've been having more research come out. We've been having these studies being done with the adverse childhood experiences. We're starting to how it's having great impacts on people's physical health, on their mental health, on their outcomes as adults. Those of us that have been in the field for a while also can see those intergenerational impacts because we've had an opportunity not only to work with families, but as these children have grown up and they themselves sometimes have been involved in domestic violence relationships, we're seeing patterns continue. We also are starting to see in the field of epigenetics that is developing, we're starting to see that how trauma and things like domestic violence is having a very impact on how our DNA is shaped. So we have to be accountable for a lot of different reasons. So trauma-informed approach is an approach that many of these agencies that you guys are representing and coming from, more and more people are starting to get on the bandwagon for trauma-informed, starting to realize that it's more than just a buzzword, that's kind of the gold standard. So we're starting to think more and more, we're becoming more aware of the impact of trauma. Child protective systems, including CPS, including the courts, they're starting to become aware of how do we minimize the trauma of what our kids are experiencing, especially the idea of removing children. We're going to talk a little bit about how that used to be kind of the standard approach. There's been a greater focus on providing emotional and physical safety to kids. Physical, we kind of always knew. We're starting to think more about emotion as well. And there's also this recognizing that adults and caregivers are also survivors of childhood trauma. And so thinking now about that, some of the people that we're working with, they are carrying what we, in the infant mental health field, we call it the ghosts in the nursery. These experiences that you had as you were growing up, that are now impacting your parenting. And so an example I like to give is that if you think of a child that you're working with, a 17-year-old male, who has been dealing with domestic violence all his life, whether he's been witnessing it, whether he's been a victim of physical or emotional abuse in his own home, and then this 17-year-old boy becomes an 18-year-old man and has a child of his own, and is then a perpetrator of domestic violence. The 17-year-old child and the 18-year-old man are the same person. And yet a lot of times in the way we break down systems, we forget that this experience translates. And of course this is going to have an impact on how he's going to be in a relationship. And of course this is going to have an impact on what kind of parent he's going to be. So we're going to be talking about the two different categories of how we are accountable to children, protection and support. And protection is kind of like that bare bones, like the legal checkbox of what we have to do to be accountable to children. So the biggest components around that are the child protective system, the legal system, and this is usually, we have more of a focus on kids remaining or being placed in environments that allow them to experience physical and emotional safety. So we kind of know that bare minimum, right? We have to keep the kids physically safe. We're starting to realize now, what is the emotional impact in certain environments? How is this allowing them to express themselves and develop as individuals? But this is kind of the outcome most of the time we think about for kids, we have to do this. And as long as we do this part, we're good. We have been accountable for kids. The box has been checked. What I also want to emphasize is that the other ways that we are accountable for kids is providing that support. This is the ethics checkbox. This is what we should be doing, but sometimes it gets lost. Sometimes as we're trying to just struggle with the drama of what's going on and helping the parents get situated with all the courts and all the systems we've talked about today, we sometimes lose that support piece for kids. And so some of these support services we're going to be talking about later on are around therapy and advocacy. So, any of you that have been in the field for a while know that there used to be, for the idea of protection, there's more of a concept of when there's domestic violence in the home, you go in the home, you get the kids, and you get them out, right? Because it's an unsafe situation. And bottom line, we have to focus on the safety of kids. But this is kind of set up like a lot of adversarial relationships between child protective systems and between like domestic violence advocates, where then they weren't sharing information with each other because there was this idea that for the domestic violence advocates, you're just going to take the kids away from the victims I'm working with. CPS is saying you're being uncooperative, you don't care about the kids' safety. And so it was a lot of breakdowns of communication. So there's been a lot of work done over the years where there's been more communication going on. We're starting to think of best practices. Now I'm going to be talking about how it's supposed to be. I fully recognize that sometimes that does not always happen. Sometimes we are still going this route, and it takes a lot of communication, a lot of work to bring us back to this place. But what we're trying to do now is focusing on helping that non-offending parent safety plan. So their kids are safe regardless of their decision to stay or leave the abusive relationship. So this might be, we've had a lot of people have been coming in and trying to educate Office of Children and Family Services and therefore DHS workers. And so one of these folks is David Mendel, and he's been doing a lot of research about this area. It's a gray area that makes many people uncomfortable because some of our victims are going to choose, I want to stay in this relationship. And so maybe someone like a child protective service worker has to kind of sit with that and go, okay, you want to stay. That's a gray area. That means that something might still happen with this kid. Now they're trying to step back and go, so how do I treat the parent as the expert of their situation? And recognizing that there may be a very good reason why they're choosing not to leave at this time, that that is considered to them a more unsafe decision, and that what they are doing in staying in this relationship really is the best thing to protect their kids. And so stepping back and figuring out what is going to be the safety plan. Nobody likes to have a conversation with a 5-year-old about what you're going to have to do if fighting becomes intense and how you're going to access a neighbor or call 911. It is a horrible conversation. And yet sometimes that safety plan is going to make more sense than removing a child from a home where a non-offending caregiver has been doing a pretty good job taking care of these kids, have been doing everything they can to try to keep them protected, to try to minimize what they're experiencing from the domestic violence. So it's a balancing act because it's not a perfect area and something that we're all still trying to navigate to think about best needs for the family, best needs for the kids. So there's the role of the mandated reporter. Now all of you come from different educational backgrounds and different policies of your agency, so I don't want to go through like, here's what you have to do as a mandated reporter because all of your agencies are going to have different protocols around it. So if you've not had a conversation with your supervisor about what you should do if you suspect child abuse, please have that conversation. But I want to skip that real quick, and I want to go here, and I just want to kind of get a quick survey from the audience. When you have that situation, when you're working with a family, and you're thinking you might have to make that hotline call, what are the common concerns that come in? Because nobody can tell me that I make these calls all day long and it never makes that yucky feeling in my stomach come up. So what are the concerns that are popping in our head, whether they are valid or invalid?
It'll make the situation worse.
Yeah, I'm going to make it way worse once I make this call. Absolutely. I saw a hand back here somewhere.
The parent will no longer trust you and
Okay.
work with you.
So that's going to completely destroy our relationship, right? As soon as I call CPS, parents not going to have anything to do with me, and I'm going to lose them.
What if it's unfounded?
Right.
I think this is terrible. What if they don't find it?
Right, so I'm going to do all this, I'm going to potentially damage this relationship with the family, and it's going to be unfounded anyway, so why even bother, all right? I would love to answer to all of you like, don't worry about it, that never happens. But you know I'm all lying about that, right? Yes, all of that stuff can happen. And a lot of times we become very uncomfortable involving CPS. But the reason I highly encourage it is because CPS can sometimes be the doorway into getting services that a lot of our families weren't able to access before. Any of you that have ever worked with a family before and had it where like, the issue was they couldn't find affordable housing. They couldn't get into a different neighborhood. It was important for their kids to still access services, but finances were a boundary or a barrier. Or they were thinking about childcare. All of a sudden, CPS gets involved and doorways open. Security deposits become available. Daycare assistance is set up. That public assistance application that had stalled out forever gets pushed through. So it is not always a negative thing. In fact, I would encourage a lot of times that involvement kickstarts things going. it's also an opportunity to hold parents accountable. And that's not always necessarily in a way of accountability, like it's a punishing thing, especially for our non-offending parents, but it's an opportunity to go, we know you have goals, that you want to keep your kids safe. We want to believe that the parents we're working with do want what is best for their children. And so we're trying to step back, recognize that, and give them an opportunity of, okay, you want what's best, this is what you're saying, how do I help you achieve these goals? So just a different mindset, just something to hold on to as we're having that feeling as we don't want to call CPS, is that sometimes this is what's going to be helpful for moving a family to the next step. So when it occurs that we actually make that child protective report, many of you are familiar with the system, so I will go over this very briefly. Most of us know an investigation is one thing that has to occur, right? 24 to 48 hours, CPS worker has to make contact with this child. After that is when things can change, right? We can have the case be unfounded, and everything kind of closes and it is as if it never happened. We also can have it where a CPS worker says, it looks like you guys could really use some support right now. Let me put some preventive services in place, services that are going to support you and your family. And they may choose then to back out at that point. They may say, I'm going to put services in place, but that's because I now have to take this to family court. I feel like there's enough evidence right now that there is concerns that your family's not going to be able to get back on track without outside intervention, and so these services are going to be put in place. And sometimes, yes, orders of protection are put in place. Sometimes we have CPS workers that are leaning a lot of pressure on parents that, like, if you don't put this order of protection in place, you risk losing your kids, which we could argue about how helpful is that going to be, and so we have a lot of CPS workers that are kind of trying to reflect about this. This is actually going to help the family. But these are possibilities that could happen after we make that report. The other thing I want to point out is that when we're talking about protecting kids, we also have to remember that the offenders, those that are the parents to these children, are still the parents to these children. That part doesn't change. So as horrific as something they may have done to the partner or to the kids themselves, they are still the parent. And so we have to think about how are they still to be responsible for the well-being. So one thing we have to know is that a lot of times family court is going to order ongoing contact. And we're going to talk a little bit about how some of that visitation might happen. And so sometimes the kids want that, and sometimes they don't. So we have to think about, how can we make this situation the best that we can? How can the kids go into this feeling safe, like they have a choice? And yet at the same time recognizing that, again, this parent is still responsible for the development of this child. Offenders are still in the role to provide support and resources to their children. So I was talking about David Mendel, who's done a lot of research and talking about safety plans and offender accountability. And he gave a great example at a training I'd gone to about working with an offender who had decided after an order of protection was put in place, he was going to keep the family van. That I know that, my wife and the kids need this van to be able to have transportation to medical appointments and going to the school and all that, but that's my van, so I'm holding on to it. And so then the CPS worker had to have a conversation and had to then get to the point where they explicitly said, so I want to make sure I'm documenting this correctly. You're telling me that you care more about your kids than anything in the world. You do anything for them. You're horrified that this order of protection has been put in place, that you can't be with them. Yet you're also telling me that you're refusing to give them something that is necessary for their well-being, for transportation, for things they need so that your partner can still take them around, that is more important for you to hold on to the car and for them to have the consequences for that. I just want to make sure I'm documenting that. And when you have that conversation that way, it does put it in a different perspective to make sure that offenders realize, regardless of your feelings about the other person's or your existing partner, your kids are still a priority. You're still responsible for providing for them. We also want to be able to provide resources to offenders to learn how to be good parents. Sometimes it can be so tempting that with the parents we work with that we just want to write them off. They've done horrible things. They shouldn't be allowed to have contact with these kids. If there is an opportunity, though, where we can give them resources, where we can give them supports, because they're going to be having contact with these kids, we need to do that. We need to figure out, to recognize that these kids may still want contact with their parents themselves, and how can we make them better parents? And we also know that sometimes some of us in the community are in a position where we have to assess the levels of support the offender can provide for the kids' needs. And that might be, can this offender be emotionally present for these kids? Can they take care of their emotional and physical needs? Not every offender can. Not every parent has the capacity to be the parent that they need to be for their children. All right. So then we get into like super supervised visitation. I kind of put this under both protection and support. To go over, most of the time supervised visitation is court ordered. Not many people are voluntarily saying, we've separated and I will voluntarily agree to have someone supervised. So it's usually a court order. The problem is that you'll have a lot of families that you work with and they'll say, the judge has ordered supervised visitation. Now maybe they're not involved in the family or the child protective system. Maybe they themselves have gone for an order of protection and they've asked for this. If the judge has not ordered what we consider more formal supervision, maybe through the visitation center that we have with the Society for Protection and Care of Children, a lot of times that's going to fall under informal supervision, which means the non-offending parent has to identify someone they feel safe with to provide that supervision. Maybe it's a family member, maybe it's someone else that they feel safe with. So sometimes people feel, oh, okay, this has been ordered, of course they could just go to the visitation center. If that has not been ordered by a judge, that means that the person is going to have to voluntarily pay for it, and not many offenders are willing to do that. We also know that there are services that exist out there in our supervised visitation that is for high conflict custody cases or when the children just refuse to see the other parent. So at the visitation center, we have two kinds of supervisions. We have supervised visitation, therapeutic visitation. So our supervised visitation, this could be done by someone from the SBCC staff or it could be done by the DHS worker. It's more of a role of like an active observer, right? You are providing interventions, if necessary, that provide education, modeling, coaching, but a lot of times you're kind of watching and giving them an opportunity to kind of figure things out, stepping in when needed. You can decrease the method of supervision needed or change it when there is a safety concern, so there's flexibility to the discretion of the supervisor. And it's also an opportunity to provide documentation to the family court and or DHS regarding how are the children doing during these visits, how are these interactions seeming, are they appropriate, are they getting their needs met. The other type is the therapeutic visitation. And the biggest focus on therapeutic visitation is on the children's needs. We want to be able to figure out what do the kids need out of this. And so all the assessment, the treatment, the advocacy, it is all focused on how the kid is doing now and how this is going to impact them in the future. So therapists might meet with the parents before and after the sessions to kind of talk about how do you want this session to go today, what are some things that you want to make sure you're doing. After the session might be how did you feel that went, were there some things that you wish you had done different, or maybe some things that the therapist can reflect that you did really well at. The therapist may also meet with the child alone too to kind of check in with them. How do you feel like things are going? Is this what you need out of this? They're providing therapeutic interventions and feedback during the session. And again, the same thing, documentation may be provided to family court and or DHS. So it's just another support that we have for kids that's available. So going on to support, and that part of like the more ethical checkbox of what we need to do for kids. Available resources vary, right? You have your general support. Schools are great. They provide a safety net that helps pick up a lot of kids, but they can't do everything. We know a lot of our schools, especially right now, the Rochester City School District is just swamped in trying to figure out staffing and all of that. And so not every school is going to have a therapist or a counselor that's available or a social worker at all times to be able to help with kids and some safety concerns. There are things around therapy that is available. There's both individual level with just the kiddos, dyadic with the kiddo and the caregiver, and family work. So the FTIP program does that, SBCC, Mount Hope, Hillside, Villa of Hope, Strong Behavioral, Genesee Behavioral, and Tree of Hope. And then there's just your more comprehensive services. So Bavona is the best example we have in our area. And Bavona's got that comprehensive idea that's kind of one-stop shop, right? You can go in, be able to get some speaking with someone from the legal team, from police, to a therapist, therapist for kids, therapist for adults. So it's just very comprehensive. It covers a lot of different avenues. In accessing these services, you might be thinking, great, how do I connect families that I know that these kids need these services? So these services here, the FTIP, Mount Hope, Hillside, this is what we consider preventive services. This is usually when we need a direct referral from Child Protective Services or the preventive unit or impact. But if you are out in the community, if you are just working with a family, outpatient services are going to include Tree of Hope, Strong Pediatric, Genesee. That's one that you can leave the number for the family to call themselves, that you can do a referral to. Schools can make referrals to, doctors, medical personnel, etc. So thinking about, when we talk about support for kids, I want to just make sure I cover a little bit about why therapy might look different for kids versus adults. And one of the things I want to emphasize is that kids in general need safe spaces to be able to process things. And safe spaces, I mean physical spaces and also just feeling emotionally safe where they can be. So what's interesting is that children are usually going to respond to therapies that include play and expressive arts. So I have a lot of parents that I'll work with, and I take the kids and we meet, and I come back, and I really think that the parents think that we're sitting opposite from a table and like having like a very deep conversation. And so I have to explain how kids use play. That is how they express themselves. That's how they see the world. And so that is how they are communicating with me. The therapy is going to be very child-centered, and so many times when parents get their kids in therapy, they have some goals, right? These are the things I need you to cover with my kiddo. But we are also checking in on what does kiddo need, and whether they say or cannot say, but are they expressing they need safety and security? Do they need to be believed? Do they need to feel like this is a person that they can trust? We're focusing on that. When we do individual therapy with adults, it makes more sense. They're adults, they have a higher level of cognition. But children benefit a lot more from dyadic and family therapy because they need to have their caregivers involved. They need their caregivers to know how events have impacted them and how they see the world. So when we're working with younger children especially, kind of like ages like 7 and under, we have to think about a couple things. We have to think about that younger children don't have the same vocabulary as adults. So the idea, again, talk therapy is not always as helpful. It's also that, children themselves, trauma resides, we know so much research now, that trauma is residing in the body. And so kids are using their bodies and they're expressing, and so sometimes your session might be with a child that you are just running and running and running, because at that point, that is what their body needs, that's where the trauma is residing, and that's what they need to do. So again, that child-centered idea. The other thing I want to emphasize is that even ages 0 to 3, this is the idea that we often want to believe the kids were too little to remember it, right? Like this happened, but they were in another room, or they're sleeping, or again, they're only 6 months, they're not going to remember. But knowing that yes, this stuff does reside in our body, and that kids do need that support. They need to kind of know, if any of you remember going back to your school days and you were learning about Erickson's theory of development, we had trust versus mistrust. That age of 0 to 1, that's that critical time we have to learn, is this world safe? Are the people around me safe? Can you meet my needs? Is the world going to be something that could support me, and when I'm feeling scared, are you going to help me regulate my emotions? So it's so important that even if you don't see a kid any observable symptoms, you think, they're fine, they adjusted. There was these horrible instances of domestic violence, but they seem to be doing okay. They can still benefit from doing therapy with an adult, again, with their caregiver then showing, I'm here, I'm going to keep you safe, we're going to be able to figure this out together. In general, the things that even if you yourself maybe are not providing direct therapies to kids, to know that what kids need is safety, support, trust, hope, communication, and a nurturing climate. You may only be able to do one of those things. You might be able to provide a decent environment for that child to be able to come into. You might be able to provide a sense of hope. But what you can do does not have to be a big therapeutic intervention. I want to just read something. The Psychotherapy Network, on the most recent issue, had an article that talked a lot about trauma, and had this really good paragraph that I just want to read for you real quick. And the healing from therapy goes deeper and lasts longer than we previously thought. When Julia Marat and other German psychologists studied refugees with PTSD, the number of breaks in the refugees' DNA was equivalent to that of people who had been exposed to an atomic bomb blast. I want to say that one more time. The DNA was equivalent to that of people who had been exposed to an atomic bomb blast. That's how badly trauma affects every cell in the body. But after therapy, not only were their PTSD symptoms gone, but their DNA was as healthy as people who had never been traumatized. The healing was complete. Think how powerful that is. Think of that when you're working with kids, that even though they've seen some horrific things, that with these things in place of safety, support, trust, hope, communication, nurturing climate, you have the ability to literally change the building blocks of who they are, to reshape their DNA so that they are going to have more positive outcomes and to be able to change their worldview. That is really powerful stuff. And it's something that I want to leave you with as a hopeful note, is that even though a lot of our kids are going to be dealing with some tough things, that with the right kind of support, we really can make a huge difference in kids' lives. Any questions? Yes?
So
So there is difference in resilience, how you deal with the trauma. And with the same therapy, some children will have complete healing, like you say, even the deep wounds. Others don't have that resilience, and they need continued therapy, and they don't really fully recover. How can we increase the resilience?
Honestly, so the question was regarding resiliency, why some kids are able to go through therapies and they are able to come out great, and other kids it feels like nothing is changing. And what I would go back are to the basics. Like when we're talking about we're providing this therapy, do we still have these in place? Like after they leave the therapy rooms, are those things in their home environment? Are they actually feeling safe and support and trust and hope? So are we involving the families? Are we looking at this in a bigger perspective? Because sometimes the reason the resiliency is not there is because this all sounds great in this nice little room where everything's perfect and clean and safe. None of this applies in my real life. So it's going back to how do we increase all these factors for kids? And I absolutely feel like when these are taken care of and foundation of safety and security is there, that is when resiliency and healing can take place. I think we're out of time. Any other questions real quick? Wonderful. Thank you. Thank you.
Good afternoon. So my name is Kelly. I am the program manager for the Elder Abuse Prevention Program at Lifespan, and I'm very appreciative of the opportunity to come here this afternoon and talk with you all about our responsibility in working with older adults. And I'm going to spend a lot of this presentation sort of looking at a court card that was developed by our team and an advocate card that was developed by our team to drive best practices in working with older adults. But I'm going to back up a little bit and explain to you sort of why this was developed and where we come from and the work that we do. For those of you who've never heard of Lifespan, we are a social service agency that serves older adults and caregivers in Monroe and some of the surrounding counties. Our program in particular has a 10-county catchment area, so we're working with older adults. I'm going to say older adults a lot during this presentation. Sort of the standard there is people who are age 60 and older. I didn't make it up, I just get to talk about it. And I think that it's important to keep in mind there's a lot of diversity in that population. So, bless you. Thank you. So just because someone falls into the category of older adult, and I'm going to be talking about accessibility issues related to physical health, it doesn't mean everybody over the age of 60 is going to have these issues when you work with them. It's just something to keep in mind sort of as best practices and issues that could arise when you're trying to serve this population. And how it's really all of our responsibility to make sure we're providing services in a way that older adults feel welcome to access them and feel like they can be easily utilized when they do decide to reach out. There we go. Okay. So thinking about what might involve an older adult in some of our services, we have elder abuse. And by definition, if we distill that down, it's a pattern of behavior being done by a trusted individual that results in harm to the older adult. There's lots of different types of elder abuse, lots of different tactics that are used. I'm not going to get into all of those here, but it's important to know it's this pattern of behavior, it's a violation of a trusted relationship, and that often multiple types of abuse are co-occurring. And it certainly could be intimate partner violence, but we're also involved in situations where it's an adult child, an adult grandchild, a caregiver of another nature that's perpetrating this abuse. And then we have scams and identity theft. And this is really all about the money. That's what's driving all of these scammers. And unlike elder abuse, for the most part, when a scam is taking place in an older adult's life, the scammer is not known to the older adult, especially in the beginning. Sometimes as part of the scam, they will develop a relationship or the facade of a relationship. If you think of romance scams, right? So they're sort of presenting, the scammers presenting themselves as a potential romantic partner to the older adult and developing a relationship in the mind of the older adult, not really in reality for the scammer. And then we sometimes work with crime victims. And
and I think it's important to know that sometimes elder abuse and scams can be pursued through the criminal justice system. Often it cannot. So when thinking about crime victims, certainly can involve perpetrators or suspected perpetrators who are known to the older adult. It may not be. It may be happening over a period of time. It may be a one-time event. So these all sort of intermingle, but they can also be distinct in their own right. So a few years ago, Lifespan received funds from the Office of Victims of Crime, and we created a project called the Elder Justice Advocate Project. And what this focused on is training professionals who are already interfacing with older adults in the criminal justice system and sort of identifying them and asking them to come alongside us and be advocates for older adults. So making sure they're aware of best practices in working with this population, and that they particularly are trained in trauma-informed care in working with older adults. And I'll say it was really successful. New York State embraced this. We had advocates in every county in New York State, and they were trained through, they were trained through webinars, and they were trained through in-person trainings at different points in the state. And why is this project important to us? So if you haven't heard it before, I'm telling you now, the population in the United States is aging. We have more and more folks over the age of 60, and that's expected to continue for the next few decades. And much like Kiki kind of referenced earlier, we've all been children before. God willing, we're all going to be older adults someday. We really want a system that's going to support us should we be the victim of abuse or a crime. We also know that there is this large population of people. We know that elder abuse and crime is happening. It's happening to adults in every corner of every county in the state, and it's highly underreported. So approximately 1 of every 24 cases of elder abuse is coming to the attention of an agency that could possibly intervene and assist. And I think that's important. So not only, because when we talk about older adults, right, they have the right to engage in services with us or not. They're adults. So they don't have to work with us, but only 1 in 24 are even being really identified and offered that assistance. And it could be coming to an agency like ours, to Adult Protective Services, to law enforcement. But again, it's a very small percentage of cases. And we know that those who are victims of crime are reporting those events at very low numbers. And we have some idea of why. We know that older adults face accessibility issues in terms of getting into services. So again, I'm going to speak sort of in generalities here. This certainly isn't going to apply to everyone. But if there's issues with mobility, whether it's actually transportation, getting from one place to the next, or whether it's when I get there, there's a very long walk to the office I have to go to, and I'm using a walker, and I've really spent all my energy just getting ready for the day to even get in the car to get here. Folks deal with hearing issues, they deal with low vision issues. So are the forms that you're giving someone, is the print large enough for them to read what you're asking them to sign? Is there enough color contrast between the words and the paper that they can actually make out what you put there? Are there a lot of really pretty fancy graphics that they can't make out because they have vision issues? And all of that can just sort of be too much. I'm not going to bother doing that. They don't serve people like me. Are the materials your agency or your services are putting out there, do they include pictures of older adults so older adults would feel like they might be welcome at your agency? And we know that providers hold bias. We know that certain beliefs that we all have need to be challenged sometimes for us to really serve a population well. And are we holding on to feelings that maybe all older adults have dementia, so I'm going to ask them questions and I can't trust what they're telling me because they have memory loss. We know that's not true. We know that even with some levels of dementia, older adults are able to accurately report what has happened to them in most instances. And we know the majority of older adults don't have cognitive impairment. So we really need to sort of question and challenge our own beliefs around aging and our own beliefs around working with older adults. Any questions about that so far? And the hope, the hope in this project is to break this cycle, the sort of disengagement with the systems that would be available to help older victims. And this graphic, I don't own it, it's not mine. It was developed by NIJ to really look at the cycle of attrition and sexual assault cases but it really is applicable to working with older adults who are, suffering trauma, who have been experiencing some level of abuse, mistreatment, or victimization. And our hope was that at some point in this cycle, we would be able to break this. There's not going to always be one spot that we can break the cycle, but to train people who are interfacing with older adults all over the place so that they're able to hopefully create better engagement and offer services to older adults. So the Elder Justice Advocate court cards. So part of this project was the training of Elder Justice Advocates. The other part was looking at a needs assessment for what the court systems felt they would benefit from to help serve older adults in a more welcoming manner. And far and away was this issue of increased access, right? So the ability to get older adults into the courtroom. And that wasn't really something within the scope of this project, but something that was creating a bench card. And I know everybody has in their packet of handouts, we actually called it a court card, not a bench card, with the hope that it would really be applicable to anybody involved in the court system. And we also created a card for Elder Justice Advocates, which I don't think is in your packet. I am going to talk about it a little bit here, and I have very pretty glossy, shiny copies of both of them back and in the back corner here. If anybody wants one of those, certainly pop back to see me. I'd be happy to give you a bunch. So this is the Elder Abuse Court Card, and this was really created to be a roadmap for folks in the court system to find the statutes and the laws that are going to support the work that they're doing. So you don't see everything really spelled out in definition. You see points of interest, a couple key issues, and then pointing you where you could go for more information. And that really was what was identified as the need when this project was kicked off. So I just want to highlight a few of these because I think that they're important. You can see in bold on your cards, anything that really relates to increased risk of lethality was really highlighted for anyone who would be using this card. They talk about co-occurring disorders, mental health, and substance abuse, and I think that that's an important one because sometimes folks think, well, substance abuse isn't something older adults deal with. They don't drink, they don't use drugs, these aren't issues that they have. They are, and they do co-occur with mental health disorders, and they co-occur with physical health disorders. Sometimes, it's that physical health disorder that brings on the use of an opiate prescription that then results in problematic use of that drug. Chicken and egg doesn't matter. Here we are, we have co-occurring disorders, and we know that co-occurring disorders make an older adult more likely to be the victim of elder abuse. We also know that co-occurring disorders happen with these suspected perpetrators working on these cases that we work with. And that can result in more unpredictable behavior on the part of that person. And again, possibly increasing the risk of lethality to the older adult. So I like how this really spells out, we know it's happening on both ends of this. And here are some potential remedies. You'll see these little justice scales that kind of tells you where to go for more information. And problem-solving courts, those are very attractive to the folks that we work with. We hear over and over again when we do work with older adults who've been victims of elder abuse situations, I don't want that person to be locked up. I want them to get help. I want them to get better. And this is something that our victims can also often really get behind and see that process through. Again, talking about health considerations, these are not going to be relevant for every older adult that you work with, but they will be for some. And I wanted to draw special attention to this issue of sundowning. I don't know if folks are familiar with that. I see some yeses. So basically when someone has, bless you, some level of cognitive impairment, sometimes there's a feature that comes along with that where their symptoms become worse in the evenings and later hours of the day. They may develop additional behaviors that they don't have earlier in the day. They may wander, they may become aggressive, they may become agitated. So if you are working with an older adult who's been a victim of elder abuse or a crime and they are known to have this, it doesn't mean you can't work with them, it doesn't mean they can't be a reliable reporter of what's happened to them, but it may mean that you need to schedule your appointments and court appointments earlier in the day so that you're catching them at a time when they really can engage in the process in a way that's meaningful. And then the other point I just want to draw your attention to is this financial or physical dependency. So oftentimes when we're working with an older adult, the person who's allegedly perpetrating the abuse is also helping that older adult in some way, whether they're providing hands-on physical care, may not be in the way I think it could be best done or that you think it could be best done, but they are doing something that helps that older adult remain in the community or remain independent in some way. And so we really are responsible to look at this big picture. If we're talking about instituting interventions that are maybe going to remove this person from the older adult's life, how are we going to account for all of the other things that are being done by that person that is keeping the older adult somewhat independent? The majority of older adults are living in the community. There's sort of a misconception that elder abuse is only happening in nursing homes or facilities, that most older adults are living in nursing homes or facilities. They're not. They're in the community, they're our neighbors, they're our friends, and we need to keep in mind that there's sort of a symbiotic relationship where there are things happening that are keeping the older adult there. All right, so that's the first page. The second page on the top, I think it's really important to point out, New York State does not have a specific elder abuse law. And this is a really tough one when we're working with families, because they look at this situation and say, they're abusing my mom, that's illegal, call the cops, have them, you know. It's not as simple as that. There is no specific law against elder abuse. There are some enhancers within the laws that can be used at times. And that, again, pointing people who might find that helpful to the statutes in the law. All right, and this is the other card that I don't think any of you have. And it's very, very tiny, so I will just highlight a few of the pieces of it. And then, as I said, I do have many copies of it, so feel free to grab a few before you leave today. I think it's a really good card to look at. It has really purposeful steps you can take to reduce barriers to older adults accessing your services. Again, things like, what are your print materials? What's the noise level where you're meeting with the older adult? We work with people all over the place. We meet them in their homes. They come into our offices. I meet people at Burger King sometimes to have a discussion. And if I'm there, what's the noise level? Are they going to be able to engage with me and hear me in a way that they can have a meaningful conversation? Folks with difficulty with hearing or hearing aids don't do well with a lot of background noise, a lot of music. So are you creating an environment where you can have a good discussion? Lighting is a big one. Tripping hazards. I know we all really think throw rugs are beautiful and they're warm and they're welcoming, but for someone who has a gait that's a little bit of a shuffle gait, or they're walking with a walker, those are really big tripping hazards. So are those able to be removed or modified when you need to? So that's the first part, and then the rest of the card is really spent talking about trauma-informed care with older adults. And I know Kiki touched on that as well. Most of us are pretty aware on some degree of this idea of trauma-informed care, that it's something we should all be doing with everyone that we work with. But I just want to point out that, at its baseline, abuse is trauma, and I don't think anyone is going to argue that point. But when talking about older adults, some of them are going to have had a lifetime of trauma. And they're coming to us with those experiences from childhood, and then experiences from early adulthood, and now they're in their older adulthood. And all of these things are cumulative. You don't sort of have one traumatic experience and it's sectioned off over here, and then you have another one and you keep it over here. These things build on each other, and it becomes a big part of the work that we do. We also know that people who are suffering trauma can demonstrate symptoms that mimic cognitive impairment. So it can, sometimes people might get dismissive of someone, saying, well, they're obviously very impaired, when in reality, it's the trauma of the event that they've just suffered. Bless you. And then there is the back of this card, which is really going to be tough for you to read, because it's very detailed information about how to demonstrate trauma-informed care with older adults. And I think the takeaway that I just want to point out is to really stay person-centered and focused on the older adult. So not only has the abuse or the crime or whatever has brought this person into your sphere, has that taken away their safety, their security, their sense of self-determination on some level. But our society as a whole tends to take that away from us as we age. And so I can't tell you how many times I go to a meeting and the professional I'm with addresses maybe me instead of the client because they think I'm gonna be the more reliable reporter or I'm gonna have more information that can be obtained. The same with adult children. You hear all the time, you go into a doctor's appointment, the doctor says, hi, Mrs. So-and-so, turns right to the daughter, tell me, how's Mrs. So-and-so doing, and not really working directly with that person. So I think, yes, we all know that person-centered care is important, but to really think about it in the context of ageism and what has been taken away from some of these folks as they've aged and giving that back to them, that they really are the expert in their situation. And that they are going to make choices that other members of their family do not like. And we are going to support them in making their own choices. Okay, so we have a few different services at Lifespan. I wanted to just point out, we also have the SEAM program, Stop Elder Abuse and Mistreatment. It's a 12-week psychoeducational program that is for offenders or alleged offenders of elder abuse. It doesn't run consistently, it runs on an as-needed basis, but there has been some really interesting outcomes from that program. And we also have enhanced multidisciplinary teams. So these are teams that are currently being launched in every county in New York State, and they are focused on financial exploitation of older adults exclusively. And they bring together within that community all of the professionals that are willing to come to the table who interface with older adults, who interface with financial exploitation. And it's one spot to sit and hear the concerns, brainstorm, create a task list, accept responsibility for what your agency is going to do to protect this person or assist this person. And then they can reconvene as needed. So the older adults themselves do not come to these meetings. It is a professional who's working with the older adult who brings a case presentation and seeks feedback from other people in the room. So I would encourage all of you to keep that in mind if any of you are ever working with an older adult and there are concerns of financial exploitation. You too can bring a case to the Enhanced Multidisciplinary Team. It's open to any professional who feels that would be helpful to them. And like I said, Monroe County was one of the first counties to do this. They're now in every county in the state. So if you are operating in counties outside of Monroe, know that is a resource available to you as well.
Kelly, what's the gateway? How do you access that?
Yes, great question. So if you call the Upstate Elder Abuse Center at Lifespan, you will be connected with a woman by the name of Allison Granata, who is the point person for the Enhanced Multidisciplinary Team. And then every county does have their own coordinator. So she would take your information and send that out to the appropriate coordinator for that county. Are there any other questions? I know I kind of whipped through everything pretty quickly. Yes.
So what questionnaire do you use to tell an elderly person her cognition is average, below average, or so low that she needs special care?
Yeah, that's a great question. So the question was sort of how do we assess people's cognition, capacity, understanding for making decisions and understanding what's happening to them. And we are not medical staff, we are a team of social workers. So we have an assessment that we can use. It's very quick. It's a snapshot of how people are operating right now. And if we look at that and we get a concerning result, then we would work with getting a full medical evaluation. We can work with geriatric neuropsychologists to really look at someone's understanding. And it's a great question because that is a big factor in a lot of the cases that we have. Can the person, are they making choices of their own free will or are they not really able to do that? And it becomes a sticking point for some of our cases. So we have to sometimes do a lot of assessment with medical providers and doctors. Sometimes we're able to do an assessment ourselves, a real quick one, and feel okay about that, but it's going to be on a case-by-case basis. That's a great question, though.
So, but what is in your quick snapshot?
Yeah, so we do the mini-cog. So what we do is it's three words, 3 nouns that we give the person, and then there's a distraction question. So you give them the 3 words, you make sure that they can understand them and repeat them back to you, and then you ask them to draw a clock, and you ask them to draw a specific time on the clock. And then you ask them to repeat those 3 words back to you. So it's a potential 5 points that they can get. There's 2 points for the clock, you get them all or you don't. And then there's the 3 words, each word is 1 individual point. So it's just sort of a snapshot of how they're doing that day. You can't take that into a court and say this person's lacking capacity, they need a guardianship. It's really a baseline, a real quick snapshot of how they're doing that day and determining if you need further assessments or not. Other questions?
Thank you.
All right, that does it for the day. Thank you all for being here. We ran just to the edge of time, and I know we ran over on some of our sections, so I appreciate all the presenters' flexibility in working with us on time. And all of the presentations are available and can be downloaded. Just contact Michelle, and she can help you get a hold of those. And if you have any questions, you can also feel free to contact me directly. Thank you.
And evaluation.
Are there evaluations? If there's evaluations in your packet, so if you could please fill those out, the pink sheet, I'm being told. That would help. Thank you.